Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. How we doing today, chat? How are we doing today? I'm here. You can all breathe easy now. You can all breathe easy. I'm very happy to be with you. Oh my gosh. Okay. So here's the deal, y'all. Here's the deal. I was not actually planning on streaming today. I wasn't planning on streaming at all because I am in the midst of something important. I am in the midst of completing my continuing legal education that I have not presently finished. And I'm doing that so I can have my, I can have my license back because we want to have my license back. Well, I want to have my license back. I don't know if you guys care as much, but I care a little bit about it. So I'm in the middle of doing that, which means I'm just sitting in my office, cranking away. And I don't mean that in a, in a gross way. I mean, just sitting there while I watch and consume tons and tons, just hours and hours of video. And, there's great stuff in there. Like, for example, today I was, I've been burning through some ethics hours, and I was watching a CLE on bullying in the legal profession. So I have some good new ideas. I've got some ideas on how to handle people now. We're gonna how to bully. It's crazy to me. Watching the bullying one especially, because it's like, how many of you have dealt with bullying? And I was, because they like do some of them live and they record them and then they're available for replay. I was like, anybody who raised their hand in there as a grown ass adult who's a lawyer, anybody who raised their hand. It is unacceptable. Why am I on Wi-Fi? What the hell? We shouldn't be on Wi-Fi. We should be on Ethernet. Okay, it doesn't matter. But yeah, so I was just like, I was marveling at this because I can't fathom I can't fathom being a lawyer and being like, I'm being bullied. I need to be saved from bullying. What is happening? Why is it? It switched to Wi-Fi, which is weird. Give me just a second. I'm going to try something. It's probably going to be dumb. If I drop, I'll be right back. Okay. For whatever reason, my internet is on the Wi-Fi, which is, and so I turned off Wi-Fi and the Ethernet isn't working, which is very strange. That's not what's supposed to happen. Give me just a second. Give me just a second. This is gonna screw everything up, I bet. Okay, hopefully we've got sound now. Hopefully we've got sound now. It muted me because it disconnected the microphone. Sorry about that. All right. So yeah, a bunch of stuff needs to be like, restarted and everything, but I was just watching videos. But where is the window I am looking for? Holy crap. I'm getting everything back to where it was. But anyway, the reason I'm streaming today, sorry, I'm very distracted. The reason I'm streaming today is because Tyler Robinson's defense has filed their motion or their brief in response for the preliminary hearing, or they called it the preliminary hearing brief. I'm going to show you the difference between the two, between the state of Utah's filing and the filing from Tyler Robinson. And it's really important. Like, the distinction between them matters. And I know that that Baron Coleman, Ian Carroll, and Candace Owens are out like running damage control on this. They are way underselling exactly how bad this is for their narrative. It's not bad for the defense as a real practical defense team. It's not great. It's not groundbreaking. It's not bad. It does what it's supposed to do. It does what's expected to be done. What it doesn't do is in any way challenge the idea that Tyler Robinson murdered Charlie Kirk. And there's a real fucking good reason for that. Because Tyler Robinson probably murdered Charlie Kirk. And they know it. And they know the state is proving it pretty handily. What they're trying to do is mitigate the death penalty. They're trying to keep Tyler Robinson alive. But these fucking lunatics out on Twitter and YouTube are pretending that, one, that they have any concept of how to do this, which they don't. And that's obvious. But two, that they have the better plan. And if you just wait and keep watching, it's all going to come together. It's not going to come together. They don't come together. One comes, then the other one doesn't get to. That's how it goes. That's how it is in the sheets. That's how it is in the streets. All right. There is nothing about this case that is going the way that they are suggesting it is going. And it's not even frustrating anymore. It's just so dumb. But they're out. They're talking about how this filing's like this great thing. They're a little confused as to why it does nothing that they've been saying that it would do. Nothing that the defense should do or the strong case. None of that. All of that is left out. Shockingly absent from the filing. And they are trying to hang their hats on literal perfunctory statements in the introduction and conclusion, and ignoring the fact that those statements don't have an argument section. They don't have an argument section. They're just kind of required to say it. It's embarrassing for them. Again, not for the defense, because Tyler Robinson knows he shot Charlie Kirk, most likely, has likely told his counsel, I was up on the roof. I did point a gun at him. I did pull a trigger. I don't, someone else might have shot him. I don't know. I'm not admitting to guilt, but like, what can we do to keep me from dying? Cause I really regret doing this. And can I possibly have a life later? Like, if I can get out of prison before I die, that would be good. And now they're trying to do that because that's what the practical application of law is. That's what happens when you have someone's life in your hands. It doesn't happen on YouTube. It doesn't happen on Twitter. They don't have anybody's life in their hands. They just have money. Money, interest, attention, accolade, fawning respect, whatever it is. And it's all great stuff. Of course. And we all want that stuff. That stuff is good. It makes us feel fantastic. It makes us feel alive, appreciated, smart, capable. It is validation, direct, immediate validation of your efforts, direct, immediate validation of your knowledge, direct, immediate validation of your appeal. Take it from me. I know exactly how it feels. That being said, that's not an excuse to lie over and over and over again about what the defense should be doing. And then, of course, people like Andrea Burkhart are out there doing actual, quality, competent, experienced legal analysis at very, very deep levels. The kind you don't leave, right? Her work on this case is fantastic and neutral. It's not salacious. It's not inflammatory. It's not explicit. Like, that's mine, right? Like, my work is also great and phenomenal and all those things. But mine is more like I'm making fun of dumb people and fat people and stretched people, apparently. This is one of the new things. They're like, this is the real photo. It isn't. That's not the real photo. I don't know what else to say. People are like, prove it. How do you prove? Like, and then you post something or you share something with someone where they showed exactly how the image was created and how it's not correct. It's not accurate. And they're like, nope, just ignore it. You're just a fed or whatever. It's like, no, I'm not. I wish. Do you think I would be sitting around on probation if I was a fed? Holy fuck. If I was a fed informant and I was still on probation, somebody should beat me with a hose. If you don't know what I'm referring to, we might talk about it. But long story short, just yesterday or the day before, Candace Owens released a picture from the real security camera, the one that doesn't behave in any way that any of the existing security cameras behaved. And she's like, this isn't Tyler Robinson, because the guy's kind of stretched. He has shoulders. Like, I don't know what that's like, but it looks like he has shoulders. And Tyler Robinson doesn't, because he's a dopey little twerp. I think we talked about this on my last show. But anyway, he's a dopey little twerpy guy. And so he doesn't have shoulders. He's a little scrawny bitch. That's my word. I get to say that. These are our terms. But he's a little scrawny bitch. And so they're like, well, no, this guy looks like he has a physical, like a frame and is bigger. And so the way they got that is to literally take a section of a fisheye lens and drag it and expand it. That doesn't work. That's not how you do that. And they've been saying that that's the original picture, the original video. It's not edited. It is. I mean, it's clearly edited, but it's not edited. And that actually, no, the prosecution edited the video and then presented it to court as if no one would find this out. Like, conspiracy is always possible, but the idea that for whatever reason, Charlie Kirk's the target, Tyler Robinson's their patsy, because Jews hate both of them. I don't know. Who knows? But like, conspiracy is real and really possible, but it's getting more and more difficult because a leak anywhere ruins everything. And the opportunity for leaks to the conspiracy are more abundant and more ripe now than they ever have been in all of human history. It is harder now to do this. The more technology is advanced, allowing crazy conspiracy stuff to happen, it is similarly given access. It's democratized access downwards to people who would have never been able to blow a whistle before. Used to have a man on the inside. Now everybody has access to everything. Like, just imagine you're rigging all the camera footage, right? And any jackass act like due to some phishing scam opens up the security key to the fucking university security cameras. And you find out that none of the cameras actually take video that way. They all look different. And so, like, imagine what that would do. It would undo everything because someone clicked on a phishing email. Conspiracy doesn't work like this anymore. You can't have like this grand lockdown scheme because everybody's got a fucking phone. Everything's recorded. There are pictures everywhere. Someone will be taking a selfie and someone will be jerking off like in the background with a menorah or something. Like, you'll figure it out. It'll always come out. But these people are convinced that there was this, that's a completely different person because someone stretched an image across and that no one would find. Now, mind you, they say they have the full video, but they haven't played it. Why? Why wouldn't you show it? They also apparently haven't provided it to the defense because the defense didn't give a shit about any of this. They didn't raise a single bit of this issue because the defense doesn't believe it. The defense doesn't believe it. The defense doesn't believe there was a palm gun. The defense doesn't believe there was a second shooter. The defense does not believe there was a shaped charge. The defense doesn't believe a Jewish ninja came up and used a blow dart on Charlie Kirk's penis. The defense doesn't believe this because the defense knows that Tyler Robinson parked his car, went up a stairwell in a building to the roof, went across it, laid down, shot Charlie Kirk with his fucking grandparents' rifle, got up, ran across the roof to the other side, dropped down with the rifle in the towel with his buddy's cum all over it, and then he ran into the woods and he set the rifle down to try and get it later, and the cops found it exactly where the video shows it would probably be. The defense knows that that's what happened. And it's not anywhere more obvious than in this filing. No more playing around, no more pussyfooting with these dumb conspiracy faggots. It's over. It's entirely over. These people deserve to be thrown up in shame on crosses and paraded through the streets to have tomatoes and shit thrown at their clothes and stain them and stuff. It's ridiculous. It is ridiculous. They just keep running with it, and people keep throwing endless fortunes at them, attacking anybody online who says anything different. But the jig is up. The jig is up. The Wiggers are wrong. That's most of them. And it's insane. I don't know how else to say it. It's insane. But again, this filing is indicative of the defense's posture. What does the defense believe about the case? And that's what we're going to talk about. I'm going to show you a clip on Twitter of Baron Coleman being absolutely retarded, as he is wont to do, right? I'm going to show you a clip of him, though, being retarded, because it bears mentioning what his approach is to this. He's baffled by this filing. It's great. Well, I'll probably go through his whole stream at some point, but for now, I'm going to show you a 3-minute clip. I don't even know if we're going to watch all of it. We're going to start with this. We'll hit the super chats and super tips. By the way, super tips are available. They are back in stock. We have memberships as well here on YouTube. You can join up on Locals. The Locals chat tonight is, it's loaded up with very relevant case data, I guess. Someone asked me if I was going to get the Locals chat back up on stream. I will do that. When I switch computers, I left my OBS profile in the cloud. I just have to figure out how to get it back onto this computer. But okay, here we go. Here's Baron Coleman, and he is looking at this document. This is just a clip from today's live stream. Now, this document came out late last night. I made a tweet about it after skimming it. I read the whole thing. The defense is not going to say Fed slop. The defense isn't going to term anything Fed slop. They don't believe in Fed slop. Fed slop is your false idol. Barron's been relying on this concept of Fed slop for a while because it shuts down critiques. No, you're just a Fed. Do I look? Don't answer that. Do I look like a fucking Fed? Tell me about all my drug charges again. But Fed slop allows people to dismiss the other argument. It otherizes the person and it dismisses the argument because they must be bought and paid for or whatever by the conspiracy. It's time to fucking come clean on all this stuff soon. These people are going to get embarrassed. None of their theories are coming into court. Not one. They are absent from this filing. But listen to the cope from this fucking loser.
Go to the bottom and look at the conclusion. We're scroll.
Hold on. Here we go.
Go to the bottom and look at the conclusion.
This is how he reads legal documents. He goes to the bottom and looks at the conclusion. Now, first of all, that's not the worst strategy ever. It's not the worst strategy on reading a legal document. Sometimes the writing is poor. In this one, it isn't. It isn't poor. It's not like the greatest writing ever, but it's a solid B+. Like they wrote their motion or their memorandum well. It's a well-drafted memorandum by obviously a lawyer with decades of experience. She's not going to win this case. She's not trying to win this case, but it's not because of the Jewish cabal or some federal conspiracy or Donald Trump wanting to jerk off on someone's pizza. It's not anything like that. She's not trying to win the case in the sense that Tyler Robinson is not walking from this. She knows that. The whole team knows that, and Tyler Robinson knows that. He's not walking away from it. The win conditions are changed. Keep him alive. Try and get a possibility of parole by showing remorse. By showing remorse. We're going to get into all of that. But this isn't the worst strategy. If it's a poorly drafted document, you might have to go to the conclusion and go, what the fuck were they saying? He's going to the conclusion for a very specific reason here. And I'll tell you about it, and then you're going to see it. But the reason he's going to the conclusion is it's the only place other than maybe one pro forma line in the intro where they say, maybe he didn't do the murder. There's no argument about it at all. They don't challenge anything related to Tyler Robinson doing the murder. They just say, well, he shouldn't be bound over for trial. That's why he's going to start at the conclusion. It's not because you need a map. The intro is adequately drafted on this filing to get through it and to make sense of it. He's like, aha. And it's actually, the funny thing is, it's in the conclusion in his own assessment of it is where you see that he's completely hollowed out here. Hollowed out like a whore on a Friday.
We're scroll up conclusion. There we go. Now we have a roadmap for how to read this thing.
I just listen to how dumb this guy is. Look, go to the end. Now we have a roadmap for how to read the document. That's the intra-fucking-duction, you dunce. What oh my God.
You read the conclusion first.
Who does this?
In relying largely on hearsay deemed reliable by rule, the state has failed to prove by probable cause. Has failed to prove probable cause by reliable evidence that satisfies each element of each of the charged evidence.
He can't read either. And what an embarrassment. In relying largely on hearsay deemed reliable by rule, that's because it's called reliable hearsay. This is a probable cause hearing. You get reliable hearsay in it. It sucks, I know, but that's the standard. The state has failed to prove probable cause. So they're literally saying by following the rule and using evidence allowed by the rule, the state has failed. Not the state could do this and didn't measure up, but by doing what they're allowed to do, they failed. That's the opening line. I said it was a B plus, but I mean, the writing is a B plus, but they don't have an argument here. Anyway, but he had...
Right there is them saying, that is the defense saying, we concede nothing.
That's not what the defense says, by the way. That's not them saying we concede nothing. This document by operation can't really concede anything. They don't need to say we concede nothing, but they concede a lot. They concede a lot in this document. And we're going to go through it, so you'll see it. But he's like, that's them saying we concede nothing. Okay, where? That's not what they said. That's all they said is a pro forma, a thing that you do as a matter of course. As a matter of course, in response to the preliminary hearing for probable cause, they're saying the state failed to meet its burden on all the elements. They say all the elements. That's crazy town. Of course they met their burden on some of them, but you say they failed on all of them and you make the argument on all of them, but they don't do that. And we're going to get into that too. Hold on.
We concede nothing.
They don't say that.
We do not concede that Tyler Robinson shot Charlie Kirk. We don't concede that Tyler Robinson.
Notice how this isn't in there. Notice how this isn't the words that are on the page. This is what he's saying they say, and it's not what they say.
Did anything illegal, sent text messages, confessed to anything. They told Lance Twiggs not to comply, knew there were 14-year-olds in the crowd. We concede nothing. Anyone who tells you otherwise doesn't know how to read a legal filing.
Anyone who tells you that what they wrote on the paper doesn't say this other thing, they don't know how to read a legal filing. Oh, okay.
Or they're fundamentally a dishonest actor. I think there's a little bit of both in this, to be honest with you.
They're either wrong or dishonest. Oh, okay, cool.
So they concede absolutely nothing.
They concede a lot.
For this reason alone, the court must decline bind over. Not bind over on particular charges, bind over on everything.
They say that only in two places, the conclusion and, since we're working backwards, the introduction. They never make the argument that the state fails to show probable cause on the murder. They never make that argument. They don't even question it. It's not in there. Only in the introduction and only in the conclusion. This dummy, here's what he's doing. He is doing as this man is rubbing Bengay all over himself for damage control. He doesn't really know how to handle this filing because this filing is the opposite of everything he's been saying for months and months and months. Nothing about the timeline, no challenge to the DNA, no real challenge to those text messages. In fact, they rely on those text messages in their arguments. This man is cored out. His entire analysis for months has been, oh, they'll attack the timeline. Oh, they're going to attack the video. Oh, they're going to attack the DNA. Nope. They actually use those things to help their other arguments. This is the Schadenfreude we are looking for.
Now, then they're going to go with their strongest argument. The state has not provided the court with sufficient evidence as a matter of law to satisfy the sole aggravator.
Okay, so here's what's happening because I was talking too much. So the state makes their blanket statement, or the defense makes their blanket statement. The state didn't do their job. And he goes, then they're going to go to their strongest argument, right? And it's the sole aggravator. This is the death penalty aggravator, the sole aggravator. Then he's going to say they're going to go to their next strongest argument. Guess what that is? That's probably the murder, right? Like the murder itself.
In the information. Okay. So we know they're going to spend a long time talking about the aggravator charge. That's the charge that elevates this to the death penalty. Under controlling constitutional law and Utah Supreme Court interpretation, the court cannot find, based on the state's evidence that the circumstances presented, a great risk of death to another other than Charlie Kirk and himself.
Which, by the way, is a ludicrous argument. The idea that they can't show that he presented a great risk of death to other people than Charlie Kirk. He fired a high-powered rifle at Charlie Kirk. That's what he did. He fired a high-powered rifle, not a shaped charge, not a Jewish microphone, whatever. A high-powered rifle. He fired it at Charlie Kirk, who is surrounded by thousands of people. They're not only does the defense, guys, in this motion, the defense not only doesn't argues that that Tyler Robinson took a shot at Charlie Kirk with a rifle. They make the argument that Tyler Robinson used a precision rifle and high-powered scope to ensure the safety of those around Charlie Kirk. I'm not kidding. That's in here. They actually make the argument that Tyler Robinson's use of a high-powered precision rifle and a high-powered expensive scope was intentional to not kill anybody else. That's their defense. And remember, that's their strongest argument. Will M says the defense did? Yes. This is the defense's document. That's the defense's argument. Tyler Robinson wasn't trying to kill other people. He, in fact, made sure to only kill Charlie Kirk as hard as possible. This is amazing.
And that the shooter knew of this high probability of the death of another. In other words, they did not meet this burden.
Oh, okay.
Even if you find that he did meet, the state did meet the burden on presenting enough credible evidence that Tyler Robinson killed Charlie Kirk, we do not.
Importantly, it doesn't say even if. This motherfucker is lying. It's so funny. Like, he's right out in the open just saying that the page says something else. Their argument isn't even if you find that that there is probable cause for the murder, there's not sufficient probable cause. They don't have the even if you find. That's all in his fantasy. He has to have that in there. He has to pretend that this document says something that it doesn't.
Believe they met this aggravator burden. Finally, this is your next strongest argument. The court should decline bind over on aggravators count 6 and 7, and we'll talk about what those counts are in just a minute. So
now, notice what he does. A lot of times when you're legally briefing something, you do things in threes, right? Just like you learned in high school composition. You have your intro, your body paragraphs, like bam, 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 1, 2, 3, right? Your intro has the 3 things you're going to talk about. This is persuasive writing 101, literally entry level. Persuasive legal writing isn't really different. 3s are great. Having 3 things is good. This one only has 2. It's only the aggravator and then the other aggravators. They make a brief nod to the obstruction charges, which they say should be struck just barely. Like it's a barely anything. But you wouldn't be worried about the obstruction charges? Honestly, like you're worried about knocking out, the murder issues, except not the murder itself. They know that's going through. They know they're going to lose on that issue. And they're likely not even going to strongly defend it because it'll look better for mitigating the death penalty if there's some sort of acknowledgement that, okay, yeah, the state is proving this case out. They also don't want to perjure themselves, and they don't want to perjure they don't want to have Tyler Robinson perjure himself and damage his ability to make a guilty plea by making some sort of ludicrous argument. But he's like, they got their strongest argument and then their next strongest argument. And then he goes back. Notice what was absent from the arguments. Nothing at all about the underlying murder. The first degree intentional murder of Charlie Kirk. There is not a peep in the conclusion. There is nothing in the conclusion that says our client did not murder Charlie Kirk. And they don't have to say that, of course. You don't have to do anything. They don't even have to make a filing if they don't want. They'd all be, malpractice and blah, 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 blah. But you don't have to, right? But the only thing they said is that the state failed to meet its burden for bind over. It's just kind of a general statement. That's as close as they come to saying Tyler Robinson did not shoot Charlie Kirk. He's like, that's them saying we concede nothing. I mean, I guess legally it's not a concession, but it is an indication of posture. It's an indication of posture for the case. What is the defense thinking? What are they doing? What's their strategy? What's their approach? Their approach is keep our client out of death row.
Understand that you're being lied to. If you're talking,
that's the most honest thing that Baron Coleman has said so far. Understand you're being lied to. Who's he talking to? He's talking to his audience. He had 24,000 people live at this moment. Understand you're being lied to. Yeah, by you dummy.
To anyone, if you're reading anything that says that the state conceded Tyler Robinson killed Charlie Kirk, that person is either an idiot or a liar.
Did you catch what he said? Because it's not what he meant. It's not what he meant. But did you listen to what he said? Let's play that back because it is sweet.
Lied to. If you're talking to anyone, if you're reading anything that says that the state conceded Tyler Robinson killed Charlie Kirk,
that the state conceded. If you're reading anything that said that the state conceded Tyler Robinson killed Charlie Kirk, it's a lie. Oh, okay. Sure. Fucking tard. You're reading the defense document, you moron. It's the defense. But it's almost like his soul won't allow him to say such an obvious lie.
That person is either an idiot or a liar. There's no third option. They're either, idiot. They're uninformed, they're ignorant, or they're a liar.
Which one are you, Barry C?
If you're hearing it from a lawyer, they're a liar because they know how to read these documents. If you're hearing it...
You have just demonstrated the opposite of that. He has just demonstrated that not to be true. Oh, man. This is going to be fun.
From some Fed slopper, they might...
From some Fed slopper. From some Fed slopper. Fed slop, Fed slop, Fed slop, Fed slop. It's all Fed slop, right? Everything about your wrong argument. No, it's Fed slop. And that's going to be the excuse. Tyler Robinson's going to go to prison. Tyler Robinson very likely will get the death penalty now. He may beat the death penalty on appeal in a decade, 2 decades, 3 decades. He might beat the death penalty then. He's likely going to get the death penalty now. Okay? Just preparing you because Baron Coleman is not preparing anybody for that. Baron Coleman is preparing. He's preparing for the excuse that it was a federal conspiracy. The defense was in on it. The judge is in on it. They paid off the jury. They got to him. The Jewish space lasers were nuking their gardens and all of the things. He's preparing for anything other than the reality, anything other than the most fucking obvious truth. This case has an unreal amount of evidence implicating Tyler Robinson and has from the day Charlie Kirk was shot. Remembering that Tyler turned himself in within 24 hours. And it's not because they didn't know who he was. It's because they had already found a picture of him. And they're like, this is probably the guy. And Tyler went, oh, fuck me. Remember he's boasting in Discord? Oh, yeah, if I get the gun, I won't have left any evidence. Well, you did. You left some evidence. First of all, a bunch of video evidence. Second of all, the gun. You left that one as a problem. You also left a screwdriver and a towel, and they linked right back to you. And you also left some Discord messages to a bunch of people saying you did it, you dummy. That has been obvious from the start. But these people have made an 11-month chain of psychopathic mouth frothing. It's affecting some of my friends too. Like, they're like, I don't know. What about this? And I'm like, here's a real easy explanation. This will not go this way. Everything you know about me, let me just tell you, it will not go this way. Like, I don't trust anything. So you don't have to trust anything. You don't have to trust anything at all other than 99.9% of people prosecuted aren't prosecuted by conspiracy. And he isn't the 0.1%. That's not him. I don't know how else to say it. Okay, here, this clip's almost done.
Just be a paid operative running with talking points from a group chat. The group of 92, the group of 40, or some other group chat.
It's the secret group chats. The group chats, right? That's where it is. It's in the group chats. Let's take a brief look at just the title of their brief. The titling of their brief. Defendant Tyler James Robinson's preliminary hearing briefing. Let's compare that with the state. Memorandum in support of preliminary hearing bindover. Memorandum in support of thing. Tyler James Robinson's preliminary hearing briefing. It is the most timid title you can imagine. Not Defendant Tyler Robinson's memorandum in opposition to bindover. That's not what it says. Why? Because it isn't that. It isn't that. This is the thing. You should title this document. It doesn't legally matter, but the posture. Again, this is all about posture and what we can read into the posture from this document. But the title should be Defendant's Response or Defendant's Memorandum in Opposition to Bindover for Probable Cause. Why wouldn't that be the title? Because it isn't that. I mean, that's the most obvious answer and the most true answer. It is not that thing. It is something different. It is just the preliminary hearing briefing. They are not trying to misrepresent shit. It's amazing. 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 That right from the start, that's their posture. What is this document? Oh, it's just a preliminary hearing briefing. No assertions, no defense, no strong stance, the weakest stance possible. So we have table of contents. We're going to skip all of this stuff because it doesn't matter. It's all in there. We're going to go right to the end. Table of authorities. Look, this is a well-drafted document. It's not that long. It's like 30 pages. But it has an introduction, or it has a table of contents so that you can skim through it, so that because the law clerks for the judge are going to be going through this thing like crazy. So they gave him a nice reference point here, and then their table of authorities. This is every case, as those are primary authorities, and then any secondary authority. I don't know if they have any in here. That's all cited. Here's where they're all cited on in every page that they're cited on. This is a really nice layout for a case like this. Then they have all the statutes that are cited and where they're cited. And then here's a supplemental authority from Arizona legislative session. Here's the rules, which are not statutes. They're incorporated by statute. and then constitutional provisions and where they're cited. Where's their Sixth Amendment argument? Oh, it's on page 2. Where's their Fifth Amendment argument? 2728. All right. So again, this is a nice setup. This is a nice setup for a document that's going to be looked at a lot and very seriously by multiple people, and they give them a handy reference. Again, this is a well-drafted, very professional document. It's well done in its form. And for what it is, it's well done in general, but it's not going to do what people keep saying it will. Amy Mitchie, remember, for 9 months is long enough to make a baby. It's a screamer. Biggest fan since some Jules. Thank you. 44 Magnum Norse. We're living in Tardville. Oh my gosh, are we ever? BobTube says, confirm you invited your dealer to watch TV in your family home. Why would I confirm that? Also, no, my dealer has never been anywhere near my family home. BobTube, go find a C and get into it. Judge Maddie sent some sparkles. Thank you. Amazing Disgrace says, why wasn't the title of the stream I Told You So? Maverick Cuba says, bro, just defend Tyler Robinson. You'd be a lot cooler if you did. Everyone's doing it. Don't you want to be hip? I get messages and emails like this. I'm real mean. 69 sent some jewels. Thank you. We the Rabble says, hit his intended target, did not endanger others. That's a fancy way of saying trained Israeli sniper. That's true. That is a fancy way of saying that. Here we go.
No gun on the roof, there ain't no proof. Just like there's no proof I wasn't acting in self-defense. That German Shepherd and kids had demons, man.
They did. Imagine if Baron Coleman and Candace Owens had taken up the noble case of Sir Ronnie O'Neill. Imagine if they had taken his defense. He would be walking free right now, exercising demons everywhere. D. What said, check your Cash App and pin the Super Tips link. Oh, okay. I will do that. D. What? Oh, man. Thank you. He sent $25. $20 for the law tax, and then $5 to pin the Super Tips link. I will do that. Let me do that right now, and then we're gonna get into the document. Hold on. I gotta find my window with the Super Tip link there. There it is. Oh, beautiful windows, wonderful window, very clean windows. No handprints or DNA on them unless you want to add a little yourself. Okay, Super Tips link is in YouTube. Pinning that. And the Super Tips link is in Rumble. I'm pinning that as well. Feel free to use the Super Tip function to all of your heart's glorious desires. Or don't. I mean, you don't have to. You do have to, actually. It's required. Nicole Marie sent some jewels. Thank you very much, Nicole. And then Samantha Shoe Lover sent some jewels as well. Much appreciated. Thank you guys for being here. Oh, wait. And there were some Rumble rants. Shit. Do I have them? Do I have access to them? Are they somewhere? Just a moment. I think I do have them. I just have to go here. Cat Slave says, hi, Nick. Micro peen. Rude. That's from today. Thank you, Cat Slave. And I didn't need that pinned 58 times. There we go. All right. And then here we have Knock It Offler says the sad part is Charlie Kirk never got to Voo-Poo. That's true. That's true. Okay. All right. Here we go. We're in the document now. We're in the document now. You guys know how I do this. Well, maybe I read the document. We're going to read it. We're going to, what is this? We're going to read the document and we'll talk about it when it's relevant to talk about. All right. Introduction. On September 16th, 2025, the state charged Tyler Robinson with the capital offense of aggravated murder, aggravated being italicized for emphasis, and other lesser offenses. The state had over 10 months to investigate the shooting death of Charlie Kirk and to develop legally sufficient evidence that Mr. Robinson, quote, I want to point something out here. Again, you can read the roadmap from the start as well. I'm going to start this sentence over because I want it all to flow together and I want you to hear exactly what it says. This is the first argument they made. The state had over 10 months to investigate the shooting death of Charlie Kirk and to develop legally sufficient evidence that Mr. Robinson knowingly created a great risk of death to another other than Charlie Kirk and the defendant. The sole aggravator alleged in the information, which in theory exposes Mr. Robinson to the potential punishment of death. That is their opening salvo. Not that the state failed to prove its case against Tyler Robinson in the murder. That's not what they say. Their first argument is to say that the state didn't prove the aggravator. That's crazy. That is a crazy introduction. That's the first paragraph. Doesn't say the state failed to show our client killed that guy. What is that? What is that? That's your opening paragraph. It doesn't deny the main crime. Let's go to the second paragraph. Follow the roadmap that Barron laid out for us by going to the end. Why didn't Barron read that first? Here we go. The state's presentation of its evidence as to this alleged circumstance in aggravation at the preliminary hearing in July 2026 wholly fails to carry its burden of proof. Again, the aggravator. The state's failure cannot in any manner be attributed to any orders by this court limiting its presentation, nor does it fall within Rule 1102C1 because the state's presentation in support of this aggravating factor was not based upon hearsay evidence. Nor did this court exclude any proffered expert testimony. In fact, the court did not exclude any evidence on this subject, and it did not limit the amount of time available to the state to present its case. Okay. That's great. We're still talking about the aggravator, not the murder. Yet, the state has failed to establish probable cause that the shooter knowingly created a great risk of death to another other than Charlie Kirk and himself. Could have been a woman, right? The state is required, as a matter of law, to show more than a possibility that someone else may be killed by defendant's conduct, rather that there was a high probability of that result and that the defendant knew of that high probability. And where the state has overwhelmingly failed to make this showing, it asks the court to expand Utah's narrow construction of the great risk of death aggravator using decades-old cases from another state jurisdiction. Binding constitutional precedent, both under Utah law and the United States Constitution, demonstrate the state's failure here and why this court may not impermissibly broaden the scope of knowingly created a greater risk of death. The facts and the law require this court to strike the sole aggravating factor. That's the intro. That's the intro. Nothing, not a fucking thing about the underlying murder. Nothing about the timeline. Nothing about DNA. Nothing about assembling the rifle. Which, by the way, their assembling the rifle argument is hilarious. We're going to get to it too. Not a thing. They don't defend the murder. We don't concede anything. Baron Coleman says, by going to the conclusion. Why do you think that this dumb retard didn't read the introduction? The introduction flat out says this is the only thing in our entire brief that matters. That's what we want to tell you about. The only thing that matters. He didn't read that. He wanted to read the end. He wanted to read the end where they say, oh yeah, other stuff too. Damnation says, this sounds like a leftist wrote this. Well, I mean, high odds, right? It's a publicly, or well, it's appointed defense attorney, often very liberal. We the Rabble says, yeah, he did it, but he didn't do it that bad. And then We the Rabble says, we're still going to fry him, Utah County. By the way, like they make an effort here, but like I said, maybe on appeal.
Aaron Balanced and Tyler Robinson make a nice match, you think?
Oh, no. Stop it. Stop it. Don't bring her up. Every time somebody brings her up, I get a phone call or a text message bitching at me. We the Ravel says, as a resident of neighboring county of Utah County does LDS, good old boys law. Argument. So we're past the intro. That was the whole thing. Now we're on to the argument. The state has not met its burden to show probable cause by relying on hearsay deemed reliable by rule in violation of Mr. Robinson's constitutional rights and separation of powers principles. This is what we call, this is a throwaway argument because reliable hearsay is allowable at probable cause. One of the reasons, just for a second, one of the reasons reliable hearsay is allowable at probable cause, because I know that it doesn't sound fair and it's annoying. Probable cause is just, do you have reason to bring this case? And they say, yeah, and they have reliable hearsay. Here's one of the reasons why, though. One of the things that they're going to do is they're going to bitch a little bit, very lightly, about not being able to subpoena Lance Twiggs, who's apparently in another state. They're able to subpoena Lance Twiggs to show up at the trial, because that would be a constitutional issue. But Lance Twiggs gave an interview to the attorney in Utah. And so they allowed the hearsay, they are hearsay statements of Lance Twiggs to that attorney from that interview that's recorded knowingly, that knowingly recorded interview that was done for this purpose. They allow this rather than subpoenaing him and requiring him to undergo the burden of coming to testify twice or more times, right? This is why reliable hearsay is allowed. It reduces cost. It's judicially expeditious. It saves court resources. It saves defendant resources. It saves state resources, all of those things. I don't like it that much. All right. Okay. Believe me, from a personal story, I have a huge problem with reliable hearsay in some contexts. But this is why they do it. Because if you burden Lance Twiggs with coming to the state and then having to come back to the state, maybe he won't come back the second time. You don't want to burn out. You don't want to burn him out on the first time, right? You want him to come in and say what he's going to say the one time. You don't want him to go home after his testimony, read a bunch of retards like Candace Owens and Barron saying all the stuff he did wrong and have him change his testimony. You don't want that. You want the honest take from the start. And if you bring people in and make them testify multiple times, all you're doing is setting up inconsistent statements. You're setting up impeachment. You're confusing and confounding things for no reason, because the standard at probable cause is just probable cause. We the Rabble says, do you actually believe Twigs is a furry? I have no fucking idea. It's funnier if he is, so yes. Maverick Cuba says, I heard Stacy won't go to prom with you until you defend Tyler Robinson. That's between me and Stacy. God. She is holding out. She is holding out. Okay, back to the document here. The man with a plan says, are the children okay? Which children are you talking about? All right, so here we go. As briefed. Now, this is, again, when I say this, the argument on this issue is really, it's like a throwaway argument. They make it pro forma again. It's perfunctory, right? They're just doing it. This is not like because they have not argued this. They've already argued this before. If you remember during the preliminary hearing, Nestor said she had a standing objection to everything. Like they have a standing objection to all of this, to all the reliable hearsay. It's all allowed within the rule, but they've made the objection, okay? So they've already briefed this. They've already argued this. They're not going back to it. My problem with it is, as defense counsel, they should make the argument, in my opinion, they should actually make the argument that the state failed to make its probable cause showing for the murder. I don't think the state did. I think the state overwhelmingly showed probable cause. All right. But they should make the argument that the state didn't. Except some people disagree with that philosophy. And they say, you know, you save your good arguments and you don't waste your credibility on failing arguments. We the Rabble says, do you think Robinson is circumcised like the IDF? Yes, I think Robinson is circumcised. Lazarus AF says, but they paved over the crime scene. Yep, they did. They did. Okay, so here we go. As briefed and argued extensively prior to the preliminary hearing, and as raised as a continuing objection throughout the preliminary hearing itself, the state's extensive use of hearsay deemed reliable by Rule of Criminal Procedure 1102 violates Mr. Robinson's constitutional rights and separation of powers principles. And just says, see the constitutional amendments 6th, 8th, and the 14th, and then the Utah Constitution on Article 1. It doesn't say what about those things. It just says it violates these principles. It doesn't. There's no argument. There's no analysis. There's nothing there. Maybe they've already briefed them, but there's nothing in that sentence that is of any value to the court. This court may not bind over Mr. Robinson based upon the state's evidence consisting primarily of hearsay that has not been assessed for reliability. Now, I want to point something out. This is the argument section, okay? This isn't the intro section. If you're going to make a statement of law, the application of law, you need a citation. They cite right here the Constitution, but this statement says that they can't do this based primarily of hearsay and has not been assessed for reliability. You know why there's no citation of that? Because that is something that they have made up. That's something that's not true. It's not supported by case law. It's not supported by statute or rule. So they don't have a citation there. They're just saying the state can't do this. But the state can do this. The state does do this. The rule is that the state can do this. This is particularly true. It's not true at all. It's certainly not particularly true. particularly true as it relates to the evidence cited by the state to establish identity for all of the charged counts. Now, again, this is this is one of the things where Baron Coleman's like, he's like, look, they challenge, they don't concede identity. It's like, okay, sure, but so yeah, again, this is just, it's one of those lines completely thrown away. This evidence consists largely of alleged communications between Mr. Robinson and Mr. Twiggs. Alleged communications between Mr. Robinson and other individuals on the application Discord, and an identification of Mr. Robinson from UVU surveillance footage. So they're saying that the state didn't meet its probable cause burden related to these things, the tweets and the surveillance footage. They don't say why. They don't say what's wrong with them. And at probable cause, all factual questions are resolved in favor of the state. Now, if you can show that it's impossible, if you can show that the evidence is manipulated, if you can show that the evidence is fake, like a fake camera and the real camera image, right, that they've been talking about the past couple days, if you show that to the court, that actually can remove that. They could challenge all of the security footage if they could show at all that the state manipulated the footage and shrunk it down to make it look like Tyler Robinson instead of someone else. If they could show that the state did that and that wasn't how the camera took it, but the camera actually took a clearer picture and it's not Tyler Robinson, they would win the case because it'd be a Brady violation. Those lawyers would get disbarred. There may be criminal charges, contempt of court, perjury, all sorts of shit could happen. But most importantly, they could win the case. But they didn't do that. They didn't raise that. They just said, well, this is hearsay. And he's hard to see in the footage. But the state has, at the preliminary hearing and with the footage, they have laid out where even if Tyler Robinson is hard to see in a particular video, they laid out through video how they followed him around campus, right? Followed by video him around campus to show he took the path up to the roof, crossed the roof down, and then ran. And then that was confirmed by the Discord messages and the messages to Lance Twiggs. All they said is that those alleged communications are hearsay. Or do they even say they're hearsay? Yeah, here we go. This evidence came from or became presumptively admissible through a recorded interview between Utah County's Attorney's Office and witness Lance Twiggs. Kinda. The reason they say it became admissible through is because Lance Twiggs identified Tyler Robinson on the video. And I believe they initially got the text messages from Lance Twiggs, although I think they got them all off of Tyler's phone in the extraction. They're kind of just glossing that because they don't want to mess with this argument too much. It's not a good one. A witness, the court would not allow Mr. Robinson to seek to subpoena from another state to testify at the preliminary hearing. And I talked about this earlier. Reliable hearsay, an interview with an attorney in Utah for the purposes of presenting a probable cause can be reliable hearsay because what do we have to doubt this evidence? What is it? This is the probable cause. He made some statements to the authorities about why he believed Tyler did this. Those statements led them to statements made by Tyler Robinson. The state has failed to prove probable cause by reliable evidence that satisfies each element of each of the charged evidence. This court must decline bind over on all charges. So this is their whole argument against the murder and everything else that happens right here. That's this. That's their whole argument. It's 3 short paragraphs, very light on citations, nothing on law, entirely on a couple exhibits that they cite to, and then the Constitution generally cite to a couple amendments in the Constitution. Okay. Sounds great. Sounds great. The rule in Utah, I have this, hold on. So the rule in Utah is that the court must, the state must produce believable evidence of all elements of the crime. So the evidence must be reasonably believable. They can't come up with an insane piece of evidence to fill a gap in the elements of the crime, right? And then the judge must view all the evidence, this is probable cause standard, in light most favorable to the prosecution and draw all reasonable inferences in favor of the prosecution. All right. So when the prosecution lays out that timeline that says, this is Tyler Robinson's car, here it is, he's getting out of the car. Then here's him going on the next video. Then the next video, this is him, 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 this is him on the roof, this is him jumping down. All of those inferences are resolved in favor of the prosecution. That's why probable cause is an easy standard. It's an easy initial bar for them to hover, but it is an initial bar. If you can knock out any element, any one element, you can knock out that charge. All right. But the state has done its job here. The state has done its job establishing the timeline by video. It's confirmed by text messages that are statements from Tyler Robinson. Those text messages are coming in. They're coming in. They're coming in. They're going to be here to stay. The only way those statements don't come in is if they can show definitively fabrication. But otherwise, they're not hearsay because they're defendant statements against his interest. Those are coming in. Dabbling Debbie says, did your dealer know your daughter was on coke? No, I don't think so. Rob Price, member for 60 months. Oh my goodness. Feel my 5-year member. Also micro peen of the Kurt. You know, one's feelable, the other one's not. That's amazing. Thank you. 5 years. Let's see. We the Rabble says, it's ma'am. It's ma'am. Citing, quoting Twigs there. We the Rabble says, what is reliable hearsay and what makes it better? Heresy and what makes it better than heresy? Well, it's heresy that you can rely on. Like, you know, it's going to be there when you need it. Maverick Cuba says, everyone who's anyone, including Stacy, will be defending Tyler Robinson tomorrow before school. Find the baseball field, be there, be square. Call me geometry, motherfucker. I'm square. Stacy can rot in hell. Dabbling Debbie says, why was your wife thrown in jail recently? Wait, what? What are you talking about? That's not a thing, Dabbling Debbie. We the Rebel says, of all the poop I'll talk in Utah County, the judges are incredibly fair. This will be a fair trial. Yeah, I have no doubt. There's nothing so far that indicates it would be anything other than, you know, that it's going any way other than the way a fair trial goes. All right, so here we go. So they make their, you know, their basic argument about all the charges. Again, no citations, really little, you know, even allusions to the evidence. Now we're on to their main actual argument. As a matter of law, the state has not established and cannot establish probable cause to support the aggravator that the shooting knowingly, I think they meant shooter, knowingly created a high probability of death of another individual from the single shot from a high-powered scoped rifle from a rooftop vantage that hit the intended target. Oh, man. That's a sentence. That's a sentence. Mr. Robinson is charged with aggravated murder pursuant to Utah code, which requires the state to prove that the actor intentionally or knowingly caused the death of another individual under circumstances where the actor knowingly created a great risk of death to another individual other than the deceased individual and the actor. The state has not shown and cannot show probable cause to support this single alleged aggravator. For brevity, Mr. Robinson refers to the aggravator as knowing great risk of death. That's KGRD throughout. Okay, so they're just letting us know that's going to be their abbreviation. All right. A defendant may only be bound over for trial if the prosecution produces evidence sufficient to demonstrate probable cause that the charged crimes were committed and the defendant committed them. Notice how this is an argument. Notice how that last section was like an argument, but not really. So here we go. That citation, State versus Murphy, quoting State versus Ramirez. See also Utah Rule of Criminal Procedure 7BB. This threshold requirement is intended to, quote, ferret out groundless and improvident prosecutions, relieving the accused from the substantial degradation and expense incident to a modern criminal trial when the charges against him are unwarranted or the evidence insufficient, quoting Ramirez. As discussed further herein, the state's burden requires them to provide evidence to support a reasonable belief, and when the evidence considered under the totality of the circumstances is wholly lacking and incapable of reasonable inference to prove some issue which supports the prosecutor's claim, this court must decline bindover. We'll read that again. When the evidence considered under the totality of the circumstances is wholly lacking and incapable of reasonable inference to prove some issue which supports the prosecutor's claim, this court must decline bindover. So again, this idea that they have to accept the state's narrative or they have to read it favorable to the state, none of that's true. None of that's real at all. That's a made up thing. If the evidence is not believable, that's the first one. So again, you can't say like aliens deposited him on the roof and that's how he got on the roof. It's not a thing. That's not a thing that works. All right. So first it has to be reasonably believable. And second, when the evidence is wholly lacking, if the surveillance video isn't Tyler Robinson, if they could show that the surveillance video isn't Tyler Robinson, then that evidence is wholly lacking, right? Because if it's not him, then it isn't him. If the surveillance video was manipulated by the prosecutor, it's wholly lacking. They can't manipulate the video to make it show something that isn't true and then claim that it's a fact. That's wholly lacking. It's also not reasonably believable, but it's wholly lacking and should be thrown out. Those messages, right? They don't challenge the authenticity of those messages. Again, I have my theory why. But if those messages were sent after Tyler Robinson was in custody, as Baron Coleman has asserted over and over and over, that those messages were fake because Tyler Robinson was already in custody and his phone was taken. He has no actual basis for this, but he's asserted it to be true. And if those text messages were not possible to be sent by Tyler Robinson, then the defense would be able to show that they're wholly lacking because they're fabricated. All they'd have to show is that he was indeed in custody and his phone was indeed taken. But they haven't shown that. There's a good reason. It's not real and it's not true. That's not what happened. Tyler Robinson sent those messages. This is the opportunity, by the way. This is the opportunity for the defense to make this actual claim and argument. And they don't. They don't do it. The one thing that's been the whole, like the timeline, man, the timeline, he couldn't have done it. He couldn't have done it. The defense could have won the case because like they said, the evidence relied on for the murder in large part are the admissions made. Those admissions confirm the video. Those those admissions on Discord make the video more believable. They take a grainy video and they go, oh, this person knew exactly what happened because they said it. If they got the tweets excluded from probable cause, they would have won the whole case. How do you place Tyler Robinson there definitively without his admissions, without him saying where the gun was, without him saying it was his grandfather's gun, grandpa's gun worked just fine? It gets a lot harder to place him there. Any element is lacking. His being there is an element. If you can knock out those messages, you win. They didn't even try. Here we go. Dabbling Debbie says, show the audience your wife's most recent mugshot. It's her only mugshot, dummy. Michael W. says, are we going with the OJ defense? Look, I'm not saying my client did it, but if they did, it only meant for that one guy. Yep. Dabbling Debbie says, why did the state take custody of your wife's 5 kids? They're my 5 kids. What are you talking about? GLP 1989 says, 1, Kurt is weird, but my opinion, big win on cross motion for summary judgment. You can have that opinion all you want. I'll disagree. If he's taking it to trial, not good odds. No, that he is taking it to trial. He lost on his motion for summary judgment. That's the thing. He lost the motion for summary judgment and now has to go to trial. I don't know how that's a big win. I don't know if that's consistent, but you do you. 2, cover trailer trash Haley's criminal history. Dabble on. I don't need to. It's already covered everywhere. I don't really give a shit. You want to go look into someone's criminal history 16 years ago? By all means, go do it. That's public record. We the Rabble says, do you think confession will take death penalty off the table? I think it's possible that they will, how do I word this? It's possible that they will offer a plea in exchange for a confession that would take the death penalty off the table. If the state wins on bind over for the death penalty, which I think they're going to. GLP 1989 says cross motion for summary judgment as plaintiff. Yes, he lost that. Like he lost the cross motion. You know, all of his requests were declined. The defense didn't win all of their summary judgment motions. They won partial, but not all. Kurt did not win on his summary judgment motion. He didn't lose the case. So that's good. But he now is going for trial. Like he's going to trial now. Like, and you just suggested that trial is bad odds for him, which I agree. But yeah, that's what's happening. GLP 1989 says, please read for the class Federal Rule of Civil Procedure 56. No, Federal Rule of Civil Procedure 56 is not relevant here. We're not talking about civil procedure. We're talking about Utah criminal law. If you want to talk about Kurt's thing, catch me on a Kurt stream. All right, back to this. Okay. The court is empowered to make reasonable inferences from the evidence presented. However, the court may not engage in speculation. All right. The court isn't just empowered to make reasonable inferences. The court is required to resolve all reasonable inferences in favor of the state. That's the rule. It's not just they're empowered to make reasonable, but fine. The United States Constitution and the Utah Constitution both require courts to construe alleged aggravators narrowly. So again, this is still on the aggravator. That's their argument here. The 8th and 14th Amendments to the United States Constitution do not permit imposition of the death penalty in an arbitrary or capricious manner. And again, to suggest that the death penalty in this case is arbitrary or capricious, arbitrary or capricious, when you have the assassination of a major political figure in public in front of thousands of people who are present for an alleged political purpose, when you do that, that's not arbitrary or capricious, right? Arbitrary or capricious means, oh, well, there's a murder, that's a death penalty. I actually don't even think that that's arbitrary or capricious, because typically they have to be first degree murder. And oftentimes there's an aggravator these days. It didn't used to be that way. First degree murder was death penaltyable. Any murder used to be death penaltyable, but like, it's not arbitrary or capricious, especially capricious. I keep saying capricious. Arbitrary or capricious. It's not that when you have like levels of murder and you have, in this case, these aggravating factors present. But so there's that. But yeah, I don't think it's arbitrary or capricious. I don't, by the way, just so everybody knows this, so we're clear on this while I read this, I don't actually support the death penalty anymore because I have no faith in government to execute it. I don't, like, if Tyler Robinson gets the death penalty, like, I mean, that's the system, but I don't believe the government should be empowered to kill people anymore just because I don't think they're any good at it. I don't trust them to do it right. That being said, like, my opinion on that is irrelevant to this case. So just know that when I read this stuff, like, I believe he's going to get the death penalty. I'm personally opposed to the government. I believe the government has the power of the death penalty. I don't believe that it's unconstitutional. I don't believe anything like that. I just believe that they're fucking dumb. Michael W. says, why is Kurt going to trial? I'm so confused. No, Kurt is representing a party taking their case to trial. Dabbling Debbie says, show us your wife's child neglect court documents. She doesn't have child neglect court documents. I don't know what your deal is, Dabbling Debbie, but the charges of child neglect or endangerment or whatever were dropped from both of us. So dismissed out. Good job. Oh boy. I know that this is your hobby or whatever, and that's fine. So here we go. The objective of the law is to require that the discretion of a sentencing body in a capital case be carefully channeled by standards designed and applied to ensure that there is reasonable distinction between those murder cases in which the death penalty is imposed and those which it is not. And again, saying that this is in any way your run-of-the-mill murder is nonsensical. Like, again, I'm not a fan of the death penalty in general, but the idea that murdering Charlie Kirk at his Turning Point USA event in public at this university with a rifle, that's the same as like two guys getting into an argument and one of them being armed and shooting him. Like, obviously those are different things. There's nothing even close to those two situations. So like, again, I think there's distinction anyway. We the Rabble says, with Charlie Kirk being a civilian, is terrorism not on the table? Violence against civilians with political aim? I mean, I guess they could do a federal terrorism charge, but I don't think there's any effort to do that. The state murder charge is sufficient. In order to bring meaning to this long-standing principle, the United States Supreme Court has explained that the Constitution requires courts to narrowly construe aggravating factors in order to avoid overly broad interpretations that violate the 8th and 14th Amendments. U.S. Supreme Court has twice examined the knowing great risk of death aggravator at issue here. In Gregg, the court upheld the inclusion of knowing great risk of death as a statutory aggravating circumstance. So the Supreme Court allows it. While such a phrase might be susceptible of an overly broad interpretation, the Supreme Court of Georgia has not so construed it. The only case in which the court upheld a conviction in reliance on this aggravating circumstance involved a man who stood up in a church and fired a gun indiscriminately into the audience. On the other hand, the court expressly reversed a finding of great risk when the victim was simply kidnapped in a parking lot. Well, yeah, those two things are different. One of them causes greater risk of death to people around than the other. But again, firing into a crowded area where Charlie Kirk is and shooting it and hitting him and not anyone else is in a way fortunate for everyone else. But it doesn't mean that there was no risk to everyone else. Plus, the ensuing like stampede as firing a gun near like a crowd like that anybody could have been killed. They have a great risk of death by being trampled or otherwise injured in the commotion. Hold on one second. Okay, there we go. The same year in Profit versus Florida, the court upheld the knowing great risk of death as an aggravator based on the Florida Supreme Court's decision in Alvord versus State, which also construed it narrowly. In Alvord, knowing great risk of death was obvious because the defendant murdered two of the victims in order to avoid a surviving witness to the first murder. Okay? In each of these cases, the court considered whether the statutory aggravating circumstance was too vague and overbroad to pass 8th and 14th Amendment muster, and in each, the court upheld the aggravator because the state's highest courts had narrowly construed them. The principle that the death penalty may not be wantonly and freakishly imposed requires the state to channel the sentencer's discretion by clear and objective standards that provide scientific and detailed guidance. So here's the thing. This argument right now, this is an appeals argument. This is an appellate argument being written at the district court level. Okay. They're saying they're making a constitutional challenge to the aggravator itself. They're saying that the Utah Supreme Court needs to narrowly construe the aggravator. I don't know if they're even going to cite. Let's see. So they do cite to it in a second. They're saying that it needs to be narrowly applied, that it is narrowly applied in Utah. That's coming down here, right in this next section, section B. And that we'll get to that. So the principle that the death penalty may not be wantonly and freakishly imposed. Clear and objective standards that provide specific and detailed guidance. As a result, the state's definitions of its aggravating circumstances, those circumstances that make a criminal defendant eligible for the death penalty, therefore play a significant role in channeling the sentencer's discretion. Thus, this court must narrowly construe knowing great risk of death, consistent with the Utah Supreme Court guidance, and strike the aggravator. Speaking of strike the aggravator, Dallin Debbie says, does your wife regret destroying April's marriage? My wife didn't destroy April's marriage. Don't worry about it. That ain't your business. Drex's Unused Baldo says, GLP must be Kurt's burner, asking you to review the rules and laws in his case so you can write your opinions and arguments in whatever brief he has to argue next, since he knows you're the better lawyer. Oh, Dablin Debbie, does your wife regret losing custody of her 5 kids? We didn't lose custody of our kids, you weirdo. As a result, the state's definition of its aggravating circumstances, those circumstances that make a criminal defendant eligible for the death penalty, therefore play a significant role in channeling the sentencer's discretion. Thus, this court must narrowly construe it. Oh yeah, and strike the aggravator. I'd already read that. So B, Utah Supreme Court decisions narrowly construing the KGRD aggravator require this court to strike it here. So now we're going to get into Utah. Now they mentioned, their first mentions were Georgia and Florida, in which the state aggravator was upheld by the U.S. Supreme Court. So that's a little bit odd. It's a little bit odd for them to start the argument with that and then to move into Utah's standard. Over the course of the past 50 years, the Utah Supreme Court has had at least 3 opportunities to carefully consider the KGRD aggravator. In doing so, it has identified a minimum set of factual circumstances which must be present in order for the aggravator to be applied in a constitutionally valid manner. Mr. Robinson addresses here the 3 decisions by this state's highest court, which, when applied to the facts presented here, compel this court to strike the alleged aggravator because those constitutionally required factors are not present. Those Utah State Supreme Court cases are its decisions in State versus Sosa Hurtado. This is the one that they cite the most frequently, I believe. And 2 longstanding decisions in State v. Johnson, State v. Pierre. They are addressed below in chronological order so that this court can see how the doctrine which this court must apply in this case has evolved to require, as a factual matter, that where one or more firearm is used in a homicide, the defendant actually discharges multiple rounds, hitting and or killing individuals other than the murder victim in a series of events. These actions are the concatenating series of events, which the Utah Supreme Court first referred to in its 1997 decision in State versus Pierre, and then reaffirmed in its decision in Sosa Hurtado II, or Sosa Hurtado II, not the second, sorry, that may lead the court to conclude that the conduct alleged created a high probability that someone other than the victim and defendant would be killed. So basically, they're trying to say that originally, when the state of Utah created this, it required multiple guns fired multiple times and striking multiple people or even killing multiple people. So that's what they're kind of going with, even though that was in that case, sure. And that's probably a thing that the court was like, yeah, these are the type of cases where that makes sense, because you knowingly cause a great risk of death when you shoot someone at all. And so if you shoot the main person you're trying to kill and then you also shoot someone else, you knowingly have caused a great risk of death. Makes sense. Dabbling Debbie says, why are you pretending the state didn't seize your kids? They gave them back, though. Edith Medic says, what's the money goal to ban Dabbling Debbie? I don't know. Try me. I have no idea. Right-wing extremist 9, whatever's funny. Find a funny number. Right-wing extremist says, Nick, how are you so good at getting these people to have these bizarre parasocial relationships with your life? Oh, I send every one of them a picture of me in booty shorts. That's what I do. If you haven't gotten yours, that was the 5K locals gift. Honestly, I've just been lying the whole time. Okay, so 1 year after the United States Supreme Court decisions in Gregg and Profit, the Utah Supreme Court considered the application of KGRD in State versus Pierre. In Pierre, the defendant was convicted of 3 counts of capital murder. Pierre and 2 co-defendants tied up 5 individuals in a business establishment and forced them to drink liquid Drano. Fuck that. Oh my God, that is awful. Holy shit. Oh my goodness. I need a second. Thank you. Wilhelm Gefallen has gifted 5 memberships. Thank you, Wilhelm Gefallen. Welcome to those who are joining us at the charity of Wilhelm. If you got a gifted membership, make sure you say thank you to Wilhelm. Very, very cool of him to do that. GLP says concomitant. Really? I don't know. What's the word? What was the word? No, it's not concomitant. It's concatenating. It's not concomitant. Tell us how long your wife lost custody of 5 kids. I don't know if you understand the definition of custody and what losing it and not losing it entails. Chuck Morris, member for 10 months, says 68. You do me, I owe you one. Wait, what? 68, you do me, I owe you one. What is that? Or are you saying, is that to ban the person? Or is that maybe you owe me one for 69? I guess Edith Medic gifted 10 memberships. Oh my goodness. Thank you, Edith Medic. We're now at 15 members for the show. Much appreciated. DX Mania 95 says my contribution to the Ban Debbie Fund. Did I make a stream goal? We'll do it. Here, I never do this because it's not we're gonna do it. Hold on. Let's make a goal. Let's do 10 super chats at $10 or higher, and we ban Debbie. Ban Dabbling Debbie. And we'll set it for 2 hours. We'll ban Dabbling Debbie and call her a dummy. I don't think I can say retard in this thing, but I'll call her retarded too. There we go. There's now a poll, like a goal to ban Debbie, I guess. Dabbling Debbie says, "Why are you ashamed of your junkie wife's parenting?" I'm not. What are you talking about? E. Poindexter says, "If all else fails, blame Megan Fox, member for 12 months." Thank you, E. Poindexter. And always blame Megan Fox. That's a true thing. That's true. Let's see. Here we got oh yeah, so we're back here. So it's concatenating, not concomitant, concomitant or whatever you said earlier. Okay, so yeah, they tied them up and forced them to drink liquid Drano. I don't know if you guys know what liquid Drano does to you if you drink it, but it's bad. It's bad. GLP says, "Apologies, that's how bad you mispronounced it." That's how bad you mispronounced it. DX Mania gifted 10 membership. Don't point out my errors. This is my show, okay? GLP, thank you. DX Mania gifting 10 memberships. Thank you so much for that. That is awesome. Dino Mom Tiffany says, "Ban Dabbling Debbie." Chachunia, I just want to join in and be part of something. Me too. I hope I can do. Speaking of that, oh my gosh, I can be a part of something. Let me do this real quick, guys. Hey, you know what? I'm gifting 5 memberships as well. 5 memberships out to you lovely people. Shelly C says, "Biatch be gone, stuck in VA, stuck in Virginia, I guess." Bye, Deborah. We're moving along on the goal. It is, I don't know. How do I see the goal progress? I think I can check it here. I don't know how to check the goal progress, but it's got to be somewhere, right? Where is this? Is there goals? Does the goal show somewhere? I don't know if I can even see it. I think it'll tell me when it's done. We're 4 out of 10 so far. Okay, keep me updated on the goal because I can't quite I don't see where to see it. I know it's somewhere. Lily Smith, a member for 16 months. That's an impressive member. Lily, it's beautiful and veiny. Love you, Nick. Thank you very much. Love you back. Edith Madick says bye-bye. We're halfway there, like Bon Jovi, I think. We're halfway there. Okay, so drinking Drano basically makes you explode, like from the it's gross. It's disgusting. All right, so Pierre eventually shot each of the 5 victims in the head. Honestly, a mercy. 2 of the victims survived. Oh God, what a shitty way to go. Oh my God, 3 did not. In upholding the application of Utah's knowing great risk of death aggravator, the Utah Supreme Court found that the evidence fully sustains that the killing of the 3 victims and the creation of a setting of great risk of death to the 2 surviving victims occurred with a brief span of time, which we reformed a concatenating series of events. Emphasis added. Michael W. says Debbie is just Lady Rackets in disguise. No way, Lady Rackets is way funnier. A decade later, so yeah, they found, shockingly, they made people drink Drano and they shot him in the head, and the court did find that was causing a knowing great risk of death. They did find that. Hrunting 13 says to move the goalposts because everyone else is. They are moving. Goalposts have legs today. So a decade later in State versus Johnson, the Utah Supreme Court held that the knowing great risk of death aggravator did not apply to the circumstance where the defendant attacked a husband and wife with a shovel, killing the man. God damn. Hooveless Moose, Ban Debbie, very unbreaded. We got to be close. That's 8. That's 8. 2 more, and Debbie is annihilated. Let's see. How do you kill one person with a shovel and not the other? That's quitter talk. When the defendant delivered the injuries to the man, he was on the other side of a warehouse from his wife, and there were shelves between them. The court noted that knowing great risk of death properly applies to situations in which the defendant kills his victim in a manner by which he knows he is gravely endangering others. The Johnson court also held that the state produced no evidence indicating that the wife was placed at grave risk of death by defendant's battery of husband, nor did it produce evidence indicating that the defendant knew that his conduct towards the husband placed the wife at great risk. In Johnson, the Utah Supreme Court further explained how the aggravator is applied. It wrote, oh my goodness, there we go. A pro engineer 873 says, Raggets, why are you gay? Edith Medick says, Debbie is Lance Twiggs. And then right-wing extremist says, I saw a thing on a guy who tried to Drano himself. He had to get plastic trachea and roll food down with his fingers. I just swim out and let the ocean take me. And I think we have sufficiently banned Debbie. We've made the goal. Jenny LJ says, okay, sir. And then Eclairito says, with $50, Debbie, you get fruit cup. So we are we have met the goal. The goal has been achieved. Now I just have to go ahead and ban Debbie. Give me 1 second. We can take care of this thing right quick. Wait, I think a moderator already banned Debbie. Did a moderator take care of that one already? Because she's gone. I can't find any of the posts. Shelly C says, Debbie's got to go. She's reaching, and she's not even reaching around. Tammy Fayette says, howdy. Actually says, ho-witty. What's up, Tammy? How you doing? Welcome. Well, yep, Debbie is gone. So we can go back to our nice hug box, which is fantastic. This should be a thing with all your trolls. Well, I mean, yeah, we'll do that. Like if people show up, I guess we'll just have super chat goals to ban them. All right. So here's the reason, just taking a pause with the document and kind of getting back into it after we had a little bit of fun, too much fun. I'm a ton of fun. I'm a fun guy. So the reason that they picked this one, all right, that they picked this case, this Johnson case, where they say the guy was killed, the one guy with the shovel, and the wife was on the other side, and they couldn't have known that killing him with the shovel would somehow cause danger to the wife, right? That's because they're going to argue that Lance Twiggs doesn't know someone was behind the tent behind Charlie Kirk, because the state's theory is like the bullet could have gone right through him and hit, gone through him, gone through the tent and hit somebody, like that's relatively plausible. In fact, you ask anybody and 30-06 isn't stopping on a person. It's definitely going through them. So he would have known that was a risk, but they're going to argue that he didn't know that anybody was on the other side of the tent and couldn't have known. And therefore he didn't put anybody at risk. I think that's way different than hitting someone with a shovel. I think that's way different, but okay. DX Mania says, hopefully Debbie learned to take her meds before sending super chats. Member for 9 months. And then Pro Engineer, member for 14 months, says, making $100 for a kick. What a time to be alive. It's very silly. GLP 1989 says, how'd Quartering spend his money? You're a CPA in comparison. Well, I don't know about that, but we'll see. All right, but that's why they picked this one. It's comparison. There's a barrier between a potential victim, right? And that barrier, they're going to say is that barrier is similar. So here we go. In Johnson, the Utah Supreme Court further explained how the knowing great risk of death aggravator is applied. It wrote, Section 76.5.2021C properly applies to situations in which the defendant kills his victim in a manner by which he knows he is gravely endangering others. The defendant was convicted under a statute similar to this section, but which also includes language concerning killings in public places, when he assassinated his victim by opening fire in a crowded church. Well, yeah. So then in State versus McMurtry, this is the third case, I think, probably, maybe it's McMurtry himself. Defendant shot his intended victims in a crowded bar. These aren't good. These aren't good cases for them. State versus Saunier. Defendant made his victims lie on the ground and shot them with rapid fire from a rifle. State versus Doss. Defendant shot victim in a crowded auditorium. Now, in all those cases, the distinguishing factor is that in all those cases, multiple rounds were fired. They're going to say since he fired one round, it's not the same also. Oh, here we go.
Bitch, I got a poll for Debbie. Kurt's micropene.
Bro.
I hope she likes salt, sweaty dandruff, and painful diarrhea because Kurt got all that. More a button than a pole BT dubs. Bitch.
Debbie is dead. John's dead.
John's dead. Jacqueline Brennan says Andrew Wilson's a good one to debate to Candace Owens. He won't take her shit. Yeah, I think that'll be, I think it's going to be entertaining. I'm going to try and cover it. We'll see. Yeah, D. Watt says it's a great grift for super chatting to ban trolls. You're welcome. Thanks, buddy. Thank you. Okay, back to this. So we have in Chenault versus State, the defendant was convicted of aggravated murder. Excuse me. After shooting multiple individuals inside a church, there the defendant fired multiple shots from two pistols. Blam, 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 blam. Sorry. That's movie killing right there. Killing two individuals and injuring another and randomly shooting into the congregation. The jury recommended the death penalty, finding the aggravating factor of knowingly created a great risk of death to more than one person in a public place by means of a weapon or a device which would normally be hazardous to the lives of more than one person. The Georgia Supreme Court found the evidence supported the jury's finding. I think the evidence in this case supports that finding as well. Like it, just because they only fired one bullet doesn't mean that the rifle and firing it is only dangerous to one person. In State versus McMurtry, the Arizona Supreme Court issued a remand for resentencing because the trial court did not adequately consider mitigating evidence in course of imposing a sentence of death. The facts underlying the conviction were that after McMurtry and three victims engaged in loud discussions in a bar, he went into the parking lot, retrieved a gun, and then returned to the inside of the bar where he shot three victims, killing two and wounding a third. During sentencing, the trial court found that the defendant knowingly created a grave risk of death to persons other than the murder victims. The Arizona Supreme Court agreed because the evidence at the trial established that the Ranch House bar was crowded the night of the killings, and there were from 5 to 9 other people in the immediate area of the victims when they were shot. When he emptied his gun at the victims, appellant created a grave risk to the death of those people. Look at how much, again, just a brief pause. Look at how much time they're spending on this argument and compare it to the amount of time they spent on the argument against the murder itself. No time on the murder itself. We're several pages now, and we're still going. The other Arizona Supreme Court decision cited by the Utah Supreme Court in Johnson is State v. Doss. In Doss, the Arizona Supreme Court upheld the application of the aggravating factor where the defendant shot the victim in a place crowded with college students. And one of the defendant's shots did, in fact, wound one of those students. In the course of conduct, the defendant emptied his revolver. Under these facts, there was no question KGRD applied. So again, they're going to distinguish this with the one shot being fired. The last of out-of-state case cited by the Utah Supreme Court in Johnson is a 1981 decision of the Louisiana Supreme Court in State versus Saunier. Saunier, the jury found to be true the aggravating circumstance of the defendant knowingly created a risk of death or great bodily harm to more than one person. Louisiana Supreme Court had previously determined that this aggravator is established when the defendant, by a single and consecutive course of conduct, contemplates and causes a great risk to more than one person. In Saunier, the Supreme Court found that the execution of 2 victims lying side by side with 6 rapid rifle shots clearly amounts to a single consecutive course of conduct by which defendant contemplated a great risk to more than one person, which obviously they shot 2 people on purpose. They created risk to the second one. Let's see. GLP 1989 says, the quartering has made me like Camelot again. Sad. Why'd you stop liking Camelot? Why would you do that? Okay, so in each of these cases relied upon by the Utah Supreme Court in Johnson, the defendant filed multiple shots. Like, hold on, guys, let me put this in an envelope. We got multiple. Those are going in the drawer, buddy. They fired multiple shots from a firearm in close temporal and spatial proximity to other individuals. And in each of these cases, individuals other than the murder victims were in fact injured. They're trying to make a big deal out of this, but this isn't the standard. In 2019, the Utah Supreme Court revisited the standards for imposition of the KGRD aggravator in Sosa Hurtado 2. Sosa Hurtado 2, the defendant was charged and convicted of aggravated murder for shooting and killing Stephen. That's poor Stephen. Just prior to shooting Stephen, the defendant fired his weapon at a second individual, Isabel, which resulted in injuries to Isabel. The shooting occurred inside a smoke shop. Sosa Hurtado entered the smoke shop and pulled an assault rifle from his jacket. He first fired a shot at Isabel that missed but shattered glass case, causing injuries to Isabel. After he shot at Isabel, Sosa Hurtado turned towards Stephen and fired a shot hitting Stephen's hand. Stephen fell to the floor. He then shot Stephen 2 more times, killing him. Lily Smith gifted a Recato Law membership. Thank you, Lily Smith. Much appreciated. Much appreciated. Let's go. Brandon's here. What's up, buddy? How you doing, man? Jacqueline Brennan says, Candace Owens was so flustered today, she canceled her stream. No way. She woke up and she made that tweet where like, Lamau, I'm just drinking my coffee. Lamau, Lamau, Lamau. That's fantastic. All right. The Utah Court of Appeals had below examined the sufficiency of the evidence supporting the aggravator, reviewing Utah case law, specifically State versus Pierre, State versus Johnson, and persuasive authority from other jurisdictions. Utah Court of Appeals determined that judicial decisions about whether this aggravator applies are often influenced by 3 main factors: the temporal or chronological relationship between any actions the defendant may have taken towards the third party and the acts constituting the murder. Okay, so is it close in time or is it related in the chronology of events? 2, the spatial relationship or proximity between the third party, the murder victim, and the defendant at the time of the acts constituting the murder. So is the third party who's at risk, are they spatially close? Are they proximate to them? Are they near them physically? And then 3, whether and to what extent the third party was actually threatened by the assailant, either by direct threats or by indirect means, such as the risk of stray or ricocheting bullets. There we go. Third factor. Were they actually at risk? Could a bullet conceivably have hit them? So what do we have here? Quick look at the Charlie Kirk assassination. Charlie Kirk is giving his speech. He's surrounded by various people, although there is some distance. There is some distance between people, like he's prominent. You know, there's open space in front of him. There's not anybody immediately next, although there are people pretty close. They're not immediately next to him, a couple feet away. Don't really know if there are people behind him or not. There's a tent there so that, you know, that could stop anything. So that's what we've got. That's the setup. So are they chronologically in danger? Temporally? Yes. There are people that are present there when the shot is fired. So you have that temporal factor. It's not like he shot Charlie Kirk and then as he's running away, he drops his gun. And it fires somewhere else, not by people, I guess. Like, I don't know what you got, but temporally, it's the exact same moment. They're all there. Are they spatially present? Yes, there are people spatially near Charlie Kirk. There isn't a specific amount of spatial distance given to us by the court, so we don't know. And then third, could a stray or ricocheting bullet hit someone? And the answer to that, in my opinion, is yes. If he had missed Charlie Kirk, he had missed his neck, which he was probably aiming at his head and forgot about the drop, but whatever. If he had missed the neck of Charlie Kirk, if the bullet had gone this way, like just whizzed past his ear, right? Like something like that. Could it have hit someone behind him? Yeah. If there's someone behind him. Was there at that exact moment? I don't know. Could there have been? There could have been. Could it have struck something and ricocheted and hit someone? In theory, maybe. Right? Like if it strikes the ground and ricochets off to something, if it hits a metal pole on the tent and ricochets into the crowd, could that happen? Or one of his security people? Maybe. Those are that. I'm not making a definitive statement. I'm saying, are the aggravating factors present? I think at the probable cause stage, you've got all three of those factors. I think you can reasonably believe, making all favorable inferences to the state, that at the time that trigger was pulled and the shot is fired, there are people in close enough proximity to Charlie Kirk that they are at risk of a ricochet, a missed shot, or a stray bullet. I think you can easily say that for probable cause. Does that win at trial is different, right? At trial, that's different. But a probable cause, I think the reasonable inferences say, sure. But I don't know. I think the court could go the other way on this one. I don't think they're gonna. This one, there's no incentive for the court to take the death penalty off the table at this stage, at probable cause. They can reasonably get there. Will an appeals court take it off the table later? Maybe, right? That's a possibility. This is an appellate style argument. But the facts here can be reasonably, believably inferred to support all three factors that they just mentioned. But let's read the rest of their argument. I don't mean to cut it short. The Utah Supreme Court endorsed these factors. Sosa Hurtado 2. In its own analysis, the court embraced principles from a KGRD decision in New Jersey, State versus Price. In Price, New Jersey court found the following to be necessary in order to support a KGRD finding. The relevant facts to be considered must include a knowing or purposeful state of mind vis-a-vis the creation of a great risk of death, that there be a likelihood or high probability of great risk of death created, not just a mere possibility, and that there be at least another person within the zone of danger created by defendant's conduct. I think there are people close enough to Charlie Kirk that a shooter knows that if they miss Charlie Kirk, they could hit someone else. I don't think that's, again, at the probable cause stage especially, I don't think that's anywhere out of line. I think that's wholly consistent with the decision upholding it here. I'm not saying the court will. I'm not even saying the court should. I'm saying I believe that the court could do that. I'm indifferent as to whether or not they will, but I really don't think that the judge in this case has any incentive to take this level argument and run against those factors. It doesn't make sense for him to do so, because that can be cleaned up on appeal. If Tyler is found guilty, he'll be in prison forever, and that he'll have the opportunity to challenge it then. And likely, while I say all this, likely the defense knows this and is anticipating it. This brief is written in anticipation of that outcome. Okay? That's what I was talking about earlier by the brief gives us clues as to the posture of the defense. The defense wrote this brief as if Tyler Robinson will be found guilty and the death penalty will probably be found. And this gives him an avenue to challenge it as he has raised this issue now. He's raised the issue here. They've preserved it, and he will have plenty of time for this appeal. That's why this argument is so thorough and the other one is a throwaway. In upholding the jury's verdict at the Utah Court of Appeals decision affirming the verdict, the Utah Supreme Court found that a reasonable jury could easily find that the identified factors support the conclusion that Sosa Hurtado caused great risk of death to Isabel during the murder of Stephen. Sosa Hurtado fired at Isabel seconds before shooting Stephen. He shot at Stephen when Isabel was close by, and he specifically acted with the intent to harm or kill Isabel. In doing so, the Utah Supreme Court endorsed the concatenating series of events formulation it first identified in Pierre. In order to satisfy the aggravator, there must be acts in a series that are linked together in a meaningful way. All right, real quick, we've got a couple more chats. Cuddle Muffins sent 1,000 jewels. I love that name, Cuddle Muffins. Fantastic. Michael W. says, I would say security team and people directly in the path of the round. Most ranges make you sign a waiver saying, I understand weapon safety, use that to show he knew weapons are dangerous. It's very rare, I think, that any court allows the argument that someone doesn't know a weapon's dangerous. And it's hard to say, like, it would be hard for him to argue that he doesn't know that the rifle that he has employed to murder Charlie Kirk, he doesn't know that that is able to kill someone else. Like, he doesn't have silver tip bullets. Charlie's not a werewolf, right? Jenny L says, sent 10 jewels, says hiding. Let's go. Brandon says, what the fuck did I do? I don't think you did anything. What are you talking about? All right. And so they're going to focus on things like a series of acts that are linked together. And they'll probably try and make the argument. Like, I don't remember specifically what they wrote about it. Okay. So give me a break. We'll get there. But they're probably going to try and argue that he doesn't do a series of acts because he only fires one round, ignoring the series of acts of like lining up the shot, getting there in the first place, having the rifle, taking aim, all of those things. We have a couple more chats here. We've got Jacqueline Brennan says she also claimed the Vegas Jews bought the election and they made Trump go along with offing Charlie Kirk. Although if money bought it, Elon technically owns Trump. That's true. That's 100% true. 77 Gary 84 sent some jewels. Unk alert. JC Music Man, member for 9 months, says call your shots or risk aggravating charges. Charlie corner pocket. He just yells it out. We're going left neck. All right. Such a link between acts may be established based on the defendant's intent and knowledge of the risk and the endangered person's proximity and time and place to the murder. This is all restating stuff that's already been said. The Supreme Court found the shot at Isabel alone to be powerful evidence of his state of mind towards Isabel. Next, there was a close causal connection between the shot at Isabel and the shots at Stephen because the evidence could reasonably sustain the conclusion that he shot at Isabel to get him out of the way. Wait, Isabel's a dude? Oh, I don't feel sorry for him anymore. Finally, the shootings took place in a small area and the victims were within a couple feet when Stephen was shot. So we know that within a couple of feet is included in close proximity. We don't know that anything else is excluded, but we know that one's included. People often read Supreme Court documents incorrectly because they'll take a statement like they're within a couple feet and they'll say, well, that's the standard. The standard is within a couple feet. No, the standard is within close proximity. And we know that within a couple feet falls into close proximity. That doesn't mean that close proximity is limited to within a couple feet. It depends. Depends on a lot of stuff. If someone is, let's say, 10 yards behind someone, they're more at risk than someone who is 5 feet to the left or right. You know what I mean? If you're shooting at someone, like not in this situation, completely different, your level ground or whatever, you pull out your gun, you bam, 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 and there's someone 10 feet behind or 10 yards behind them, they're more at risk than someone who is 5 feet to the left or right. All right. So it's not like there's no easy one size fits all standard on this. Okay. So here we go. Blah, 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 blah. These facts led them to conclude that the killing and the initial shot at Isabel were part of a series of concatenating events, or in other words, Isabel was within the zone of danger when Sosa Hurtado killed Stephen. Yes, and that's what we've been reading this whole time, just restated over and over. Michael W. says, Unk alert again. Thank you. Dragonfly says, acts in a series, one shot, one act. That's going to be the defense's argument, but the acts in the series aren't necessarily, like, we haven't seen anything that says so far that the acts are specific acts of violence in the series. The acts in the series could be laying down is an act, right? Lining up the shot is an act. Finding Charlie in the scope, like, or pointing the rifle towards Charlie Kirk and also the crowd. Does that put them in danger? Just that the mere act of like lining up the shot, looking through the scope and zeroing in on Charlie Kirk. That's an act. Pulling the trigger is an act, right? All of these things are different acts, but I don't know if those are acts as far as the court is concerned, and we don't have any statements on it yet. But yeah, that is an argument that the defense would make. One shot is one act. There's not a series of acts. That's not the definition of acts, but it could be a term of art. And we got a blowfish from 300-yard wink. That's a long wink. 300 yards. Thank you very much. All right, so here we go. So we got the zone of danger. Sosa Hurtado killed Stephen. Okay, so that was a lot to say the same things and to really flesh out the three factors from Johnson and how those have been applied in other cases. So the evidence presented by the state fails to establish probable cause as to the aggravator. So now we're on to how they're going to apply the rule. So this is how you write legal, how you do legal writing. And this is called the IRAC format. It's IRAC, not IRAQ. So we don't have to invade it for 10 years. And the IRAC format is your overall document. It's also each subsection. You have your intro, your rule, your analysis or argument, and then your conclusion. Okay. So we got the intro up top at the beginning of the argument. It's in the argument section, but in your argument, you have another little mini IRAC, right? Intro to the argument, the rule that the argument's under. The first one was the intro, A. B is the rule. C is now the actual argument in the argument section. This is where we're going to apply the rule to the facts at the present case. And they had to spend a lot of time laying out the rule. It's very specific and it's common law. So it's built on other cases. So it's not as necessarily easy to discern as a statute, which will have clear language that is supporting the rule, right? This rule is developed by the court. Here's how it's looked at it. And they want to really hyper focus on that rule. That's why they wrote it this way. But now we're in the argument or analysis portion. This is persuasive, so it's an argument. So the evidence fails to establish probable cause. So preliminarily, Mr. Robinson must alert this court to a significant problem presented by the state's arguments as to the facts established at the preliminary hearing. So we've got anything italicized they believe is important. The state makes little effort to distinguish between the evidence it presented and inferences it asked this court to make based upon that evidence. This is a dangerous road for the defense. It's a losing argument because the state is required under the rule to make all reasonable inferences in favor of the state. That's what the court's required to do. So asking the state to make those inferences based on the evidence is proper. Asking the state to speculate or asking the court to speculate based on evidence is not proper. Very different things, right? Inferences are conclusions that are reasonable and notorious, right? Like an inference is something you can easily see occurring. from a given set of facts. Speculation is anything could happen. Let's do this in the backwards way, right? This does not apply to this case legally, but it is kind of an indicator of how we can see these two things and how they interact. An inference that Tyler Robinson is on the roof is drawn from the video that shows him going towards the building and up the stairwell, and then someone arrives on the roof. The reasonable inference for probable cause would be that Tyler Robinson is the guy on the roof. All right. Even if the video's grainy and hard to see, you go, okay, well, who else would it be? This is a reasonable inference. You don't even have to say who else would it be. Could it be Tyler Robinson? Well, we saw him go up the stairwell in the building that leads to the roof door, and then someone's on the roof. Reasonable inference that it's him. Speculation. It could be anybody. Well, I mean, it could be anybody, but based on the totality of the circumstances, and that's the standard, we talked about it earlier, the totality of the circumstances, who else is going up the stairwell to that roof access? Who else? Saying it could be anybody. It could be Donald Trump. Well, that's speculation. There's no evidence that supports that at all. There isn't an inference that it is someone else. There's raw speculation that it could be. Now, if you have Tyler Robinson walking up the stairwell and someone walking up the stairwell 30 seconds later, okay, now you have an inference that it could be someone else. However, of course, at the probable cause stage, all inferences go in favor of the state. So you still would lose. But that's a way to distinguish between what is an inference and what is speculative. Inference says this is a reasonable outcome from the totality of circumstances of the data that we have or the evidence that we have. Speculation is just grabbing at anything. All right, so here we go. Rather, the state pursues an unconstitutional expansion of the knowing great risk of death aggravator to this case and fails to distinguish reasonable inferences from speculation. Oh, hey, look at him go. Good job, guys. As the Utah Court of Appeals explained earlier this year in State versus Murphy, a magistrate may deny bindover when the evidence considered under the totality of the circumstances is wholly lacking and incapable of reasonable inference to prove some issue which supports the prosecutor's claim. State v. Prisby. In other words, a magistrate may properly deny bindover where the facts presented by the prosecution provide no more than a basis for speculation. While the line separating speculation from reasonable inference can at times be faint, the two are distinct. An inference is a conclusion reached by considering other facts and deducing a logical consequence from them. And speculation entails the act or practice of theorizing about matters over which there is no certain knowledge at hand. If you want to know the difference between inference and speculation, inference is what we talk about here. Inference is what Andrea Burkhart talks about. Inference is not what Baron Coleman and Candace Owens talk about. They talk about speculation. Here's evidence. This is what it could mean. It's not the logical, deduced outcome of the evidence. It could be anybody. It could be a palm gun or a microphone that exploded. Where's the evidence of that? There isn't any. That's speculative. And if you want to know why none of that makes it into this document, right here, they are saying that the state failed to draw a proper line between inference and speculation. If they put a bunch of speculative theory into their document, the judge would fucking just laugh them out of town. He'd go right to the gas chamber. And by that, I mean the judge's chambers after a burrito day. All right, so here we go. Speculation entails the act or practice of theorizing about matters over which there is no certain knowledge at hand. In short, the difference between an inference and speculation depends on whether the underlying facts support the conclusion. Furthermore, it is not appropriate to stack inference upon inference to satisfy an element of the offense. I don't know that this is true. There is a citation coming up. Quote, while inferences drawn from facts and evidence are appropriate, inferences drawn from inferences are not. State versus Cristobal. And when evidence supports more than one possible conclusion, none more likely than the other, The choice of one possibility over another can be no more than speculation. This is, I would wager, I don't know, I bet this is a misunderstanding of this quote. I bet this quote is being used improperly here. Because to say, when evidence supports more than one possible conclusion, none's more likely than the other, the choice of one can be no more than speculation. That is not a probable cause level statement. Because at probable cause, if you have two things no more likely than the other, the one that favors the state wins. You get all reasonable inferences from the evidence. So I'm betting that line is improperly cited, that this is probably not a probable cause statement. But maybe it is. Maybe it is. I don't really want to look it up right now. Maybe I'll look it up later. The following is a recitation of the evidence presented at the preliminary hearing specific to this court's determination on the aggravator and the state's arguments regarding the aggravator without drawing inference upon inference as the state asks this court to do. So this is their framing of the evidence presented and admitted at the probable cause hearing. Hetty Lamar says, Nikki, don't lose my number. I don't have your number. I would never lose your number. Gunner says, quick, did anyone see an airport catering van drive up to the roof with Trump inside? You have a bucket of chicken, beautiful chicken, wonderful Kentucky fried American chicken, not French. Jacqueline Brennan says, you mean the defense didn't bring up Vegas Jews? They didn't. They did. I was hoping for that one. Cup of Soothe says, I say it's FIRAC. One is I is issues, and you're still heading for Suplex City. I am not heading for Suplex City. You're heading for Suplex City. Okay, so here's their recitation of the facts as they frame it. Let's read this footnote real quick. The state quoted liberally from the medical examiner's report admitted as State's Exhibit 11 in its public filing. Uh-oh. Wait a minute. What are you talking about? Despite the exhibit not being published and medical records being categorically private under Utah rule of judicial administration, this appears to be another example of the state publicizing private information in contravention to the rules guiding records classification. This is an insane argument. This is an insane argument. Okay, hold on. It would have been a simple matter for the state to redact this private information. Mr. Sturgill says this is a document that does contain very sensitive information, and that information that Mr. Kirk's family would appreciate it not being published. We'd ask that it not be published here in the courtroom or to the camera. So they're saying that the autopsy information of Charlie Kirk, that violates Charlie Kirk's privacy by them using it in their document. Holy shit. Okay. Who's Mr. Sturgill? Who is this? I don't know all these names. Who is Mr. Sturgill? Tyler Robinson case. The Utah County Attorney. Okay, so he's on the prosecution team. David Sturgill. There we go. So they're saying that David Sturgill said that there is information contained in the medical examiner's report, which is private to Charlie Kirk, even though I don't think he has a privacy interest because he's dead, unfortunately for him. And they're saying that because of that, the state couldn't use any of the information. It should have been redacted. Okay, sure. I'm guessing it might involve photographs and stuff like that. I don't know what information he was referring to. So there we have that. Right-wing extremist says Tyler can still win, Nick. He just needs a new legal team and be called O.J. Simpson. I saw someone suggest, why doesn't Candace take the $300K that's being given to her by Andrew Wilson. And why doesn't she use that to fund Tyler Robinson's legal defense? Isn't Candace Owens like $100 million, like a multi-hundred millionaire from her rich husband also? Like, why don't they just hire a crack legal team? You know, and they could crowdfund it anyway. She has a huge audience. I'm sure she could crowdfund, you know, like a $2 or $3 million defense. No problem. Right? Why haven't they done that? But Candace, who's just defending her friend Charlie, and it's not about the money, required $300,000 for a debate. Good job. By the way, good job. I am available to debate anything for $100,000 an hour, whatever you want. I am for hire. I will defend anything. You give me 300 grand for 3 hours of work. What do you want me to defend? Anything you want, I will do it. I am available. My services are at your disposal. All right. Okay, so here is their recitation of the facts. The afternoon of September 10th, 2025, we can forget. If it was the next day, we'd never forget. Several thousand people gathered in and around an amphitheater on the UVU campus to watch and listen to guest speaker Charlie Kirk. I don't know why they have several thousand listed in quotes, but they do. Mr. Kirk was struck by a projectile on the left side of his neck, and the injury resulted in his death. Okay. This is the first critical factual recitation. All right. This is the first critical factual recitation. Mr. Kirk was struck by a projectile on the left side of his neck, and the injury resulted in death. He was not struck by an explosion. He did not get struck in the chest. There's not a sideways entrance wound. The left side of the neck is not the exit wound. This is the factual recitation. These are the facts. The best evidence of the events on September 10th on the Utah Valley University campus are the videos. Okay, that's the best evidence. So not speculation about shaped charges, not a t-shirt fluttering in the wind, or the kinetic overpressure. Not that. Cupasu says, did Nick just say he will mass debate for $100,000? I will mass debate on stream. States exhibits 12.1 and 12.4 are compilations of UVU surveillance footage from September 10th. At 5 minutes and 33 seconds of 12.1 and 12.4, the surveillance depicts the roof of the Low-C building. This is their recitation of the facts. Just remember that. This is the defense's factual. Well, they're claiming this is the evidence that the state presented at probable cause. This is the factual scenario of what the state presented at probable cause. This is important, not because this does not establish the factual scenario for trial. That's important, okay? Legally, that matters. Again, from a posture standpoint, what have we been told? This is not the facts you're looking for. These aren't the facts you're looking for. We've been told over and over that the facts are not this. The defense does not entertain nonsensical factual scenarios brought up by retarded people on YouTube. They don't entertain it. That's not part of the question. They know what happens if they do. They get executed with him. That's a rule in Utah. It's like the multiple wives thing, multiple executions. States Exhibit 12.1, this is the footnote, shows zoomed in portions of State Exhibit 12.4. 12.1 was received into evidence and played in the courtroom, but not published to the cameras in the courtroom. Importantly, Candace Owens has pretended to show 12.1 to discredit its clarity, to discredit the zoom, to do all of that. She did not have this. Candace Owens' video is not what was shown in court. And the way we know that, here's how we know that 12.1 did not exist yet when Candace Owens claims to have received the court video back in October. The state had not made that video yet. They had not made the compilation with the Zooms. They mentioned at the hearing that they had put those together. And if the court admitted the first video, which is the zoomed out video, they would ask the court to then admit the zoomed in video, which the court did both of those things. All right. They tried to ask for the zoomed in video first. And the court said, whoa, there's like annotations on it. There's zooms and edits. And we don't have any. And the defense properly objected. They said, we don't have foundation for this video. We don't know who did the editing, et cetera, et cetera, et cetera. And the prosecution flipped their tack and they said, okay, we'll present the unedited, like just the raw video. We'll present that. And then we're going to ask the court to allow us to use the zoomed in and annotated video, which contains some things to help people follow the narrative. Now, the court has not said that the zoomed in video will be allowed for the jury. In fact, the court could very simply say, we're not going to allow that. And the defense will likely challenge this with a motion in limine and say, you can't do that because those annotations are prejudicial. The annotations are hearsay. They lack any probative value. This is a narrative. This is testimony being given by a video editor, not actually a recitation of the events. And it's very possible they would win that. But at probable cause, this second created video was made. I think they may have even made that video during the probable cause hearing, like after the first day, if I remember right. But it's not what Candace Owens showed. She's tried to kind of like weasel in there that she has the court video. She doesn't. She has something that predates it. Now I think what she has is a screen recording of the raw video on whatever screen. We don't know anything about the screen, but it's not the raw video itself. It's a recording of it with a different device. We the Rabble says, I hope this goes to trial for your sake, the mass debater. You rather than a plea, you're saying, like Courtney Clinty, that coward. Just kidding. Yeah, I don't know. I mean, if the death penalty stays on the table for the bind over, then there's a possibility of a plea for Tyler Robinson. There's a possibility of a plea if they'll take the death penalty off the table, right? In exchange for his plea. I don't know that that's going to happen. We'll see though. All right. So anyway, right, but not published to the cameras in the courtroom. And then footnote 7 says, Officer Bagley testified that the Losi Center has 4 or 5 levels, with level 1 being courtyard level, and the top has an atrium on top of it. Okay, cool. All right, so here we go. Back to this. At 5 minutes, 33 seconds of 12.1 and 12.4, the surveillance depicts the roof of the Losi building and the walkway between the Losi building and the computer science building. Beginning at 12:20 p.m. At 6 minutes, 18 seconds of 12.4, the shooter is seen going over the railing, separating the walkway from the Losi roof. Now, again, the shooter is. All this nonsense about the video's too grainy, you can't see that there's a rifle. They're saying that the state has established that that is a shooter, that the person on the video on the roof is the one who shoots Charlie Kirk. It's not something else. And then Bagley says a little guardrail, probably about a couple feet high. So he jumps over the guardrail and then goes on the walkway. Each of the videos then jump to 12:22 p.m. when a figure is seen running west across the Losi roof. So there is a gap of a couple minutes, 6 to 7 minutes in there. The state has made some inferences that that's where he assembled his rifle. We'll get to that in a minute. All right, so at 12:22:25, the figure drops to the roof and begins to crawl to the western edge of the roof, going both south and west. The shooter reaches the edge of the roof at approximately 12:22:44, although additional body positioning on the ground is visible until approximately 12:22:56. This is, again, for a grainy blob that you can't see, they're saying, the defense is saying that additional body positioning on the ground is visible in whatever video they saw. So describing evidence of prone position in gravel on rooftop. Agent Hull testifying the shooter was prone for 15 to 30 seconds. At 12:23:28 p.m., the figure gets up and begins running to the northeast corner of the roof and drops off the Losi building roof to the ground. Officer Bagley observed shoe print in grass where individual observed jumping from roof. So exhibits 12.1 and 12.4 show the shooter was in position on the southwest corner of the Losi center roof for approximately 35 to 44 seconds. You've seen videos, no doubt, at least I have. I've seen video titles. Could Tyler Robinson line up and make that shot in 5 seconds? He has longer than 5 seconds. He has 35 to 44 seconds to line up the shot. Officer Bagley testified that there is a clear line of sight between the tent and the top of the Losi Center. So the Losi Center is here and he can see the tent clearly. This is important for the defense. They want to show that Tyler Robinson chose to shoot Charlie Kirk and didn't shoot someone in front of Charlie Kirk. Wasn't at risk of it. He had a clear line of sight at Charlie Kirk. They want these facts. Exhibit 7 depicts the shooting of Mr. Kirk from behind the individual asking him questions immediately prior to the shooting. The questioner is separated from Mr. Kirk by a barrier, a patch of grass of unknown dimensions, a table, and the space behind the table in front of Mr. Kirk. Listen to what they're doing. Remember, temporal proximity, spatial proximity. They're attacking the second prong. The questioner is not close to Mr. Kirk. He's not in the zone of danger. That's the argument here. Mr. Kirk is sitting in a chair on an elevated platform that is centered in the backdrop. The shot occurs at 32 seconds of this video. There is one individual seen to Mr. Kirk's right and behind Mr. Kirk under the tent. So again, they're trying to eliminate people from temporal proximity, which is impossible because they're all right there. Spatial proximity. And then they're going to attack the knowledge aspect. Oh, he couldn't see the guy behind him. This individual is on the opposite side of where the bullet struck Mr. Kirk. So he's seated to the right and the bullet struck Kirk in the left. So he's seated right here, right? So they're going to try and say that I believe that guy was pretty close. I believe that guy is within a few feet, right? Zone of danger, a few feet, 2 to 3 feet. I think he's right there. But they're going to say that he shot him with a precision rifle on the left side of the neck, so it couldn't have possibly hit the guy on his right. That's a bad argument, but that's going to be there. This individual's on the opposite side of where the bullet struck Mr. Kirk. The video has no timestamp. So the footnote 8, the state claims in its brief that at least 2 individuals were standing under the tent where Mr. Kirk was seated. This claim is contrary to the evidence and is indicative of the state's reckless recitation of the evidence in its brief. Now, if the judge, so here's an interesting thing. Again, the state gets factual matters resolved in its favor, and the state also gets all reasonable inferences. There is a little caveat to this, though. There is a little caveat. The caveat is, generally, courts say that video evidence is basically, assuming the video is authenticated, video evidence is the evidence. Video itself shows us what we need to see. All right. A video isn't testimony. It's not making an argument. If the video is obvious. So at least that's how it is in Minnesota. All right. So if the judge, if that's true in Utah, which I think it may be, if the judge looks at that video, now if the state and the defense disagree, state says 2 people are under the tent, defense says 1 person's under the tent, state wins. If the video, however, shows 1 person under the tent and not 2, The judge is fully capable of saying that the video is the better recitation of the facts than whatever the state categorizes them, or the defense. So whatever's, if it's visible on the video and it's clear and there's no ambiguity, the judge will trust the video. At least in Minnesota, I believe it's the same in Utah. Here we go.
I ain't even going to make a joke, dog. This shit is a great breakdown. Micropene. Fuck white people. White bread ass nigga.
Thanks, brother. Thanks, brother. You rarely get a breakdown as thorough as you get with me, but also littered with fat jokes, disrespectful comedy. Okay, so that's just to say they're calling the state out here, saying that the state's wrong. The video actually shows one person. The judge will likely go with the video there if that's true. But so anyway, so here we go. Back up to this thing. Yeah, so the individual seen in Mr. Kirk's right and behind Mr. Kirk under the tent. This individual is on the opposite side. State's Exhibit 8 begins with Mr. Kirk in the courtyard throwing hats to members of the crowd. The video has no timestamps. Beginning at 32 seconds, State's Exhibit 8 depicts Mr. Kirk seated at the table under the pop-up tent with the same questioner visible in front of Mr. Kirk. They're saying, when they say no timestamps, they don't mean like the video doesn't have an internal timestamp. It doesn't have a timestamp of what time of day it is, right? So the other videos are synced up. They show 12, 22, 21, right? Like they show that time of day. That's the timestamp they're referring to here. So State's Exhibit 8, seated at the table under the pop-up tent with the same questioner visible in front of Mr. Kirk. There are what appear to be two security personnel in front and diagonal to Mr. Kirk, standing in the grass area by the barrier seen in Exhibit 7. The camera recording Mr. Kirk is visible above and behind Mr. Kirk in State Exhibit 7, meaning the camera is angled downward. The shot occurs at 48 seconds in this video. One of Mr. Kirk's security guards comes into frame from the right of Mr. Kirk 3 seconds after the shot. State Exhibit 9 is UVU surveillance footage from behind the pop-up tent that begins at 12:21:14 p.m. The moment of the shot occurs at 2 minutes, 13 seconds in the video. Confirmed in testimony from Agent Hull, no one is immediately behind the center of the American Comeback pop-up tent when the shot occurred. They're going to focus on this as part of their argument. It is also self-evident from this video in State's Exhibit 7 that no one can see through the back of the pop-up tent. Agent Hull says you would not be able to see through it. Agent Hull testified that he can't answer what would have been visible to the shooter on the low-C center roof. Now, just a brief logical assessment of this argument. Their argument is going to be, as you'll see, that Tyler Robinson couldn't have known if someone was behind the tent because the tent is opaque, right? He wouldn't be able to see behind it. But they also make the argument that there is no one behind the tent. For the probable cause hearing, the reasonable inference from Tyler Robinson is that if he couldn't know whether someone was behind the tent, he also couldn't know someone wasn't behind the tent. And the reasonable inference is that someone could have been behind the tent, because we know someone was behind the tent at one point. And so if he had the ability to see people walk behind the tent or whatever, this is one where, again, at probable cause, the inference goes in favor of the state. The inference that Tyler Robinson could know someone was behind that tent. They're going to argue, well, he couldn't know that someone was behind the tent, but there was no one behind the tent. Well, he couldn't know that no one was behind the tent. He can't know that. If he can't know someone is there, he can't know someone isn't there. And again, the reasonable inference is that someone could be there. Probable cause, yes. At trial, different story, right? Different story. At trial, they have to prove knowledge beyond a reasonable doubt. Probable cause, they get inference. So we don't have testimony from Tyler Robinson, and without that testimony, they may never elicit this fact. Okay, so here we go. Finally, State's Exhibit 6 depicts 22 seconds of the event from the perspective of witness AW. There is no timestamp on the video, but based on the content, it appears to be taken close in time to when Mr. Kirk initially sat on the elevated platform under the pop-up tent. The state's forensic investigator, Agent Jennifer Falmuina, testified at the distance of the slope between the rooftop vantage and the pop-up tents was approximately 415 feet. Agent Falmuina also testified that the elevation difference between the bottom of the amphitheater and the low-C roof was approximately 68 feet. So 415 feet, I think that's consistent with the 147 yards. I'm not doing the math on that. The 68 feet is the elevation difference. So they're going to basically do a, triangular, like a trigonometry question of, could the shot have hit anybody? Because it's fired from a downward angle from the top of the roof down to 68 feet, which is the floor. Charlie Kirk is tall and sitting in a chair. So you probably think 62 feet. He's sitting, it hits him in the neck, not on the top of the head. So maybe 3-4 feet up, right? So you got 60, 63, 62 feet down. Finally, Agent Famina tested, the distance without consideration of the slope between the 2 points is 410 feet. So we have some math. We need an Asian for that. A Mauser Model 98 rifle was recovered in a wooden area across the street from the northeast corner of the Low-C Center, where the individual ran after jumping from the roof. That is on video, by the way. The reason they found the rifle in that wooded area was because I believe when they reviewed the video, they saw where the individual ran. The rifle was a 30-06 caliber with a scope. The rifle was a bolt-action rifle. In order to load it, lock it, as well as extract anything that's in the rifle, the user has to manipulate the bolt. Usually emotional manipulation works. You're a shitty bolt. You can't even let the bullet out, can you, you piece of garbage? When law enforcement manipulated the bolt, the rifle had a fired cartridge case inside and 3 unfired cartridges. The fired cartridge case was still in the chamber of the rifle. Cartridge was fired from the rifle weapon. That's this piece of evidence. The state's exhibits 12.1 and 12.4 also contain video of an individual the state's witness identified as Mr. Robinson entering and exiting campus parking structures 4 times on September 10th, 2025. Twice before the shooting, one at the time of the shooting, and once after the shooting, a vehicle is seen matching Mr. Robinson's on campus. The first entry was at approximately 8:30 a.m. with an individual state's witness identified as Mr. Robinson returning to his vehicle at approximately 9:25 a.m. So state's witnesses, that's multiple witnesses, have identified him as Mr. Robinson. I assume one of those is Lance Twiggs. I don't know the identity of all of them. Agent Hull testified that during this initial visit, Mr. Robinson went to the amphitheater area and spoke to some representatives from TPUSA. The second entry was at approximately 10 a.m., and Agent Hull testified that Mr. Robinson went to a Chick-fil-A in the Sorensen Center, walked to a wooded area across Campus Drive, and appears at the railing on the walkway between the Computer Science Building and the Low-C Center roof. Mr. Robinson left campus the second time just prior to 11 a.m. We have a footnote. The state did not show footage of the individual identified as Mr. Robinson's movements in and around the campus during the hearing, only the footage from the parking structures. Okay, so during the hearing, they didn't show that footage of his movements in and around campus, only the footage from the parking structures. Well, and the footage from the stairwell and I guess the rooftop, right? All right, so here we go. The individual identified as Mr. Robinson is next seen returning to campus in different clothing and walking with a limp at 11:53:05 a.m. According to Agent Hull, the individual he identifies as Mr. Robinson is seen walking in a parking structure in front of the Low-C Center and then on the walkway between the Computer Science Building and the Low-C Center at approximately 12:15 p.m. None of the footage shows the individual identified as Mr. Robinson passing by or near individuals that are clearly minors. So here they're on, they're laying this out for the other part of their argument. If he knowingly murdered someone when children are present, or when he knows children are present, that also is escalatable, right? That's an aggravating factor. A search was later conducted of the residence Mr. Robinson shares with Lance Twiggs in St. George, Utah. In the closet on the floor, they found Lance Twiggs. In the closet on the first floor of the apartment, law enforcement found some shooting targets with perforations on it. Agent Falmoina testified that the perforations were consistent with bullet holes. The target showed perforations outside the target, closer to the target, and then even closer with a perforation in the center. Probably the sighting in, right? Like that's an inference that I would make. I don't care what the court does. It's an inference I would make that, oh, he used that target to sight in the scope. We the Rabble says, Your Honor, in defense of the accused, we'd like to present an illustrated cartoon of what might have happened. He says, this is an admission of being the shooter. Utah County is fair. These arguments of extenuating danger may actually make the case, but I expect a Utah County jury is putting him to death penalty every time. Right. And notice what I said, and I'm lightly poaching off of Andrea, but I completely agree that this is written for an appellate audience later on. Jacqueline Brennan says, if Tyler Robinson just says it was BB's idea, Candace Owens will stop. Right-wing extremist says, got the video of the real assassin right next to the jar with Macron's detached ween. Now, we all know Macron's ween is actually in Brigitte's penile urethra. We the Rabble says this case would have been solved 2 years ago with flock cameras. Again, I want to say this. I'm going on record. Everybody bitching about flock cameras. My 3L long paper in law school, they weren't called flock cameras yet. My 3L paper in law school was all about digital surveillance being used and the inappropriate nature of using license plate recognizing cameras and how that amounted to what would be considered stalking if private citizens did it and should not be allowed under the Fourth Amendment. I was on these motherfucking cameras before. Any of y'all even heard of them? Well, some of you may have, but most of you hadn't. I wrote that paper in 2015. I think it was. Maybe it was 2014. I think it was 2015. I wrote that paper. I got a good grade on it too. Good job. Okay, anyway. The communications the state admitted between Mr. Robinson and Mr. Twiggs indicate Mr. Robinson's intention to kill Charlie Kirk. Quote, I had the opportunity to take out Charlie Kirk and I took it. There's no mention of any threat or intended harm to any other individuals. This is what I'm saying. They want these statements. They want the text messages. I'm sorry. What does this say? Simon Halbert says, are you aware there is a 2.5-hour recording with Kurt at his pretrial conference? No. But I want it. I want it. Dumbbeard says, flock cameras and ALPR are two entirely different things. But it's the same concept. It's the same idea. It's the fact that there's license plate recording cameras that are geo-logging your place and time, or at least the place and time of your license plate. And I don't think that that's proper, personally. Okay, so anyway, here we go. They want these statements because these statements are the way they mitigate the death penalty. They want the admissions, they have to take the admissions of Tyler Robinson because those admissions also contain statements that he only tried to kill Charlie Kirk, and eventually it'll be I regret killing, I regret doing it. We the Rabble says, my client is guilty, but he's not that guilty. That's the argument. Freedom Slurge says, drugs are bad. Look what they did to our boy, Nikki. I'm okay with me. Sorry that you're not. Okay, so here we go. D. So the argument has been made. The analysis has been made. Now we've got the conclusion of this argument in section D. I would assume that this is this is going to be them putting it all together. So this is probably This is probably still more of the argument in the Iraq formula. It doesn't matter. The court must reject the state's asserted theories as to how it has established facts supporting the knowing great risk of death aggravator because it has failed to establish the facts that are constitutionally required. The state offers two interrelated theories of knowing great risk of death that failed to conform to the criteria established by the Utah Supreme Court, criteria which, if not met, render application of the knowing great risk of death aggravator violative of U.S. Constitution Amendment 8, 14, and Utah Constitution Article 1, Section 9. Each is deconstructed here. Oh, great. Here we go. Their constitutional argument is, again, it's about the aggravating factor. First, the state has propounded a line of sight theory, which is based upon out-of-state authority that has never been adopted in Utah. It is primarily based upon the decision of courts in Pennsylvania before that state enacted a moratorium. Now, this is a little bit dishonest, in my opinion, because they cited to states outside of Utah first. That was the first thing. Was Georgia and Louisiana, I believe. Oh man, Simon Halbert. Why would you tell me this now? He says it's an attachment to document 124 on the docket. Doesn't seem to go well for Kurt at the end. If anybody can get that for me and send it to me, I would appreciate it. I'm going to forget by the end of the stream. All right, so here we go. Is primarily based on the decisions of courts in Pennsylvania before the state enacted a moratorium. For over a decade, Pennsylvania has had a moratorium on the death penalty. Moreover, the state's reliance on this authority fails to support the application of a line of sight formulation to the facts it presented at the preliminary hearing. The state's line of sight theory, as applied to the questioner to the east and below Mr. Kirk, fails because based upon the facts the state presented this court, and no further reasonable inferences based upon those facts can support that basis for the aggravator. What they're basically saying is that the state is asserting that the questioner is in the line of sight of Tyler Robinson and therefore in the zone of danger, right? Like that would make sense. If you're shooting forward and someone's in your line of sight, they're notoriously in the zone of danger. But they're going to say that the questioner is probably at too low of an elevation based on the low-C thing, based on the facts that are presented. And this is a good technical argument. This is a good technical argument. I don't think it wins necessarily, but if the judge agrees with them, then it becomes wholly unbelievable that the questioner is in the zone of danger, right? So that's why they're presenting it. Like I said, it's a good argument to make. The second theory is an everyone near argument, which relies upon only one of the three factors identified in Sosa Hurtado 2 and ignores the other two factors, which are not present here. Moreover, I don't agree with that at all. Moreover, the state asks the court to speculate about the shooter's knowledge. Even assuming that one can infer a knowledge of some risk to the shooter, not risk to the shooter, inferring the knowledge to the shooter of some risk. That's maybe an easier way to understand that sentence. The state has failed to show that the actual conduct created a high probability that someone other than Mr. Kirk would be killed, and thus this theory fails as a matter of law. Where there were people in some proximity to a discharge of a single projectile from a precision firearm with a high-powered scope, which the evidence establishes hit its intended target. Evidence establishes it hit its intended target. The single factor of proximity fails to permit an inference of a subjective knowledge of the shooter of a high probability of risk of death to others, where no other person was injured in a manner creating a great risk of death and no other shots were fired. The allegation of a knowing great risk of death aggravator cannot be sustained. So again, they're going with it's a single act, it's a single shot. That single shot hit the intended target. So there's no additional act that could knowingly cause death. I think what they're ignoring is it doesn't fail the other prongs. They're saying only spatial proximity, but it's also temporal proximity because they're present right there with him. And they're also in the zone of danger. Just because they didn't get hit doesn't mean that they couldn't have gotten hit. I believe the state also addressed in their argument that since he brought extra bullets, that were also engraved and loaded in the magazine that he anticipated the possibility that he would have missed and he would have another shot to take. That is, I think, going to be addressed here in a second. I'm not saying that that's the proper argument. It's not a bad argument. It's a reasonable inference, but that might be asking the court to speculate too hard. I don't think it really matters. Line of sight. The state broadly argues that certain individuals were in the shooter's line of fire. There are two fatal flaws in the state's argument. One is factual and the other is legal. The factual one might be more important because the factual one is where the judge can go, it is wholly impossible. Although we'll see what they are. Factually, the line of fire assertion as the questioner defies logic. The evidence established there was one shooter on the roof of the Losi Center. No palm guns. Mr. Kirk was seated under a pop-up tent in the center of a courtyard to the southwest of where the shooter was positioned on the roof. Losi directly east of the amphitheater. The single shot fired traveled from east to west at a downward slope into the bottom of the bowl where the tent was located, showing the crowd at increased elevation to the east of the pop-up tent. So they're going to say the bullet clearly sailed over the crowd and down into Charlie's neck. State's Exhibit 7 shows the vantage behind the questioner prior to and at 12:23:28 p.m. The questioner is in front of Mr. Kirk to the east. If the questioner had been in the line of fire from a bullet moving towards Mr. Kirk, the questioner would have been struck by the bullet as it traveled. This is not necessarily true. That's not necessarily true. That's a statement they cannot make. Just because you're in the line of fire does not mean you were struck by a bullet. The bullet could miss by going between your legs, under your arm, past your head, where it would have hit your chest, but it was too high. That's one thing, but that's not what in the line of fire means. At 147 yards, minor variation in degree create pretty distinct differences, multiple inches to even multiple feet in difference in where a bullet ends up. So line of fire means, can the bullet have hit them? Is it reasonable to believe that the bullet could have hit them at the probable cause stage? Again, this is all probable cause. So is there a reasonable inference that the bullet could have hit him? How far, like, if they're not in the line of fire, here's what you have to do. If they're not in the line of fire, if Tyler fucks up, and like shoots downward too much, could he possibly hit them? If he can't, because like if he shoots down too much, it would hit the ground or the roof in front of him. Well, then they're not in the line of fire, right? Like if they're below the roof line, they're not in the line of fire from his vantage point. I hope that's making sense. But if they're visible from the roof line and he could feasibly accidentally pop down a couple degrees for whatever reason, maybe sneezes, I don't know, who knows? If that's the case, at probable cause, you're probably still in the line of fire. Okay, so here we go. In fact, the state's evidence shows exactly why the questioner was not in the line of fire. The single bullet came from above. The video evidence shows that Mr. Kirk was seated on an elevated platform and separated from the questioner by a security barrier, a grassy /area, and then tables that surrounded Mr. Kirk on three sides. The bullet traveled at a downward angle and hit Mr. Kirk in the left side of his neck, where Mr. Kirk's head/neck area was elevated and an unidentified distance away from the questioner, certainly more than a few feet away. They're going back to that few feet thing. The only evidence presented supports that the bullet traveled above, not through the crowd. Footnote says the state calls this a few feet in its brief, but there was no evidence of the distance submitted to the court. The video from behind the questioner shows the distance and speaks for itself. That's one of the best lines they've had in the entire brief, honestly. This court must also reject the legal theory behind the state's factual argument. The state asks this court to adopt its interpretation of out-of-state authority on a line of fire theory. However, a thorough examination of the cases which construct a line of fire theory are not, as the state suggests, and support that this court should not expand Utah's application. Now they're going to make that argument. Oh boy. Out of charge. Out of charge on my security blanket. In Commonwealth v. Watson, Pennsylvania Supreme Court considered the application of Pennsylvania's grave risk aggravator to a case in which Watson fired 3 shots into an occupied car, striking an individual twice. Watson then shot the lock off the door of a home, pulled his ex-girlfriend from the closet where she was hiding with her 2 children, and shot her twice. He then reloaded, left the room, returned, and then shot her again, and then shot himself. One of the shots lodged in the door frame around the closet where the children were hiding, but did not hit them. Under these facts, Pennsylvania court affirmed a jury's findings as to the known great risk of death aggravating factor because the children in the closet were endangered by his conduct. Wait, that guy lived? He shot himself and failed? What a loser. Hey, what's up, locals? I see you there. In Sylvia v. State, the defendant argued that there was not competent substantial evidence to support knowing great risk of death because the gunfire was intended only for one person. The Florida Supreme Court disagreed because Sylvia engaged in indiscriminate shooting in the direction of at least 4 persons other than the intended victim, who were not only put in immediate risk of present risk of death, but were also in the line of fire. So they're going to go with the indiscriminate thing here. His was very discerning and discriminating. He picked only Charlie Kirk. One of the other individuals was shot, and the defendant pumped the shotgun and aimed it at the 2 others. The court explained, "We therefore conclude there was competent, substantial evidence that Sylvia's actions created a great risk of death to many persons. He approached the house while pumping shells into his shotgun. Pellets hit one of the cars in the carport, different locations in the carport, and the door from the carport to the house. Pellets were found inside the house in the kitchen, dining room, and bedroom. There were 6 unarmed people in the carport and house when Sylvia approached, shooting and pointing the gun at people." So there we go. In Commonwealth versus Reed, Pennsylvania Supreme Court found sufficient evidence to uphold the grave risk aggravating circumstance. Reed had fired multiple gunshots at fleeing children after chasing them in his vehicle. One of the shots hit a young man in the back, killing him. Less than a week later, Reed killed another individual with the same weapon. Court noted that 12 to 14 others were in the line of fire when Reed chased the boys while driving his car, and gunfire flashed from the windows of Reed's car, killing the first victim. So they're trying to make a discernment here that there were multiple shots is their key. That's the one that they're really going for here. In Commonwealth versus Buck, the court considered whether the Commonwealth's notice to the defendant of the aggravating circumstance was sufficient, and if the Commonwealth abused its discretion in proceeding on 3 aggravators, one of them grave risk. In finding the Commonwealth did not abuse its discretion in alleging grave risk, the Buck court found that the evidence raised a factual question for the jury because, while only one individual was shot and killed, the potentially endangered person stood behind the decedent in a bathroom, and importantly, because the endangered person wrestled with the defendant over the gun after the shot was fired. Let's take a break for a second. This is really important. This is a drafting note, and let me give you some insight into the argumentative attorney mind, okay, that we gather here. Do you notice all of these cases that they're citing? All of them support a knowing great risk of death. They're not citing a bunch of cases where there was not a knowing great risk of death found, right? Like ideally, they would want to cite a case where there was a person who was shot at, 60 yards, and that there was a person that was maybe off center. Maybe they were like in the line of sight, but not in the line of the shot. You can imagine this, right? They're off to the side by a couple degrees. Maybe they're 5 yards off to the side. So they see them, but they've got a rifle and they shoot the person they're aiming at, and they're not shooting that person. Ideally, they would want that case and then the court to find that the knowing great risk of death was improper, right? That's the ideal case, something like that, where someone is out of the straight firing line, and so they establish clearly that the line of fire is the line of fire, not the zone of danger. The zone of grave risk. That would be a good case. They're not citing that case. They're citing a bunch of cases where it was found but they're going to try and distinguish their case out of that. They're going to say that, well, in all these cases, they found these factors. Therefore, our case doesn't measure up. That is sometimes the best argument you can make. That's not great. It sounds kind of convincing. They're like, look, in all these other cases, this is what they found. But that's assuming that the court is limiting it to only these circumstances. The language that the courts have used to describe knowing great risk of death isn't limiting in the way that they're saying. It's limited to the test, the 3-part test that we discussed. It's the same 3-part test re-articulated over and over and over. Are potential other victims, are they temporally proximate? So are they around them at the same time? At the time that the acts occur, are they present? Are they spatially present? We know that the zone of danger is at least within a few feet. We don't know how big it is, but I would argue the zone of danger changes based on where they are in relation to the person. If they're next to them, a few feet, yeah, in the zone of danger. 10 feet away to the sides, that's a lot different, right? But front and back, if they're 2 feet in front of them or 10 feet in front of them, it probably doesn't matter. If they're between you, like if you shoot, they're in risk. Same thing with behind them. If a bullet goes past, misses the head and goes, past them, are you gonna clip the other person? And then the third factor, is it reasonably foreseeable that a stray round or a ricochet could put someone in mortal danger? That's going to have a lot of factors to it too, right? Like one of these cases was a shotgun. It's really unlikely that a ricocheting pellet from a shotgun is going to put someone in mortal danger. Like shotgun shells or shotgun pellets lose energy very quickly. They're fired. They're not rifled. There's no rifling. They don't have the highest muzzle velocity, and they spread out. And as they spread out, they lose the overall energy. It's dispersed in the air around them. And so if, depending on how far away one is, those pellets can ricochet and they could cause some superficial damage and hurt and not be pleasant, but mortal danger becomes less and less likely really quickly with something like that. So you can imagine the different type of gun goes into that reasonable belief analysis. In this case, is it reasonable to believe that a ricochet or a stray round causes mortal damage to someone? Yes. High-powered rifle, tons of lethality to it, even after a ricochet. All right. Unless there's something to absorb that energy, it could pass through a tent, no problem. It could pass through like a water bottle or something like that. But there are things that could cause a ricochet and it would still potentially be lethal. So that's the issue here. They don't have a great case that says we don't find knowing great risk of death in this instance. That shows the weakness of their argument, that they're presenting it as strong. I just wanted to provide that note. I'm doing a lot of reading, and I want to provide that note so that that's in your mind when you assess this. And if you ever look at other legal documents, that's the thing. What are their citations saying? Are their citations on point? Are they aligned with their case? They're showing a bunch of different cases, and they're trying to say, see, ours is different. But in all of these cases that they're showing, the court found the knowing great risk of death. They need to provide the alternative. And I don't know that they're going to. And that, the judge could go, well, in all these different circumstances, they still upheld the narrow construction of the knowing great risk of death. That gives the judge the leeway to say, yeah, I find it here. Kind of a risk. But hey, you go with the facts that you can, right? Let's see. In Commonwealth v. Buck, the court, defendant aggravating circumstance was sufficient. Yeah, we found this. The Buck court found that the evidence raised a factual question for the jury because while only one individual was shot and killed, the potentially endangered person stood behind the decedent in the bathroom, and importantly, because the endangered person wrestled with the defendant over the gun after the shot was fired. State versus Wood challenged the application in a double murder case where he did not shoot any persons other than the victims and there were no bystanders in the line of fire. The court found that although the defendant's argument had merit, the interpretation proposed was too narrow under the unusual facts of the case. The Wood Court found no single factor is dispositive. That's not good. Of knowing a great risk of death. And the inquiry turns on whether during the course of the killing, the defendant knowingly engaged in conduct that created a real and substantial likelihood that a specific person might suffer a fatal injury. So this is actually a really bad case for them. They're under like a duty to explore this, but here the court says no single factor. So if you don't have temporal proximity nailed down and you don't have physical proximity nailed down, and you don't have that third factor, the reasonable belief that someone could be caught by a stray or a ricochet, if they're not 100% unlocked, that's not dispositive. That doesn't resolve the issue. No single factor resolves it. It's all three factors brought under the totality of circumstances. Okay, so thus, the several factors in combination supported knowing great risk of death. That's a really shitty case for them. Emphasis in the original. There was the presence of others. The defendant turned to another, and it appeared as if he was going to shoot a third individual. Another employee fought defendant over the gun, and there was evidence the defendant knowingly prepared the gun to fire when he assumed a shooting stance toward one employee and when he grappled with another. None of these cases support the state's position here. I would argue that they do. But this is the argument they have to make, and that's fine. Each involves conduct directed at the endangered person, consistent with Utah Supreme Court's endorsement of the 3 zone of danger factors in Sosa Hurtado. In determining if knowing great risk of death applies, as a matter of law, this court must consider if any conduct constituting a great risk of death was directed at any individuals other than the victim. Here, there is none. I think that weighs against the third factor, honestly. The third factor is there a risk, not is there a directing. Utah has never adopted an interpretation of knowing great risk of death that would permit its application where the firing of a single shot at an intended victim that hit only the intended victim merely because other people were in the vicinity. Utah not adopting that doesn't mean much because they might not have that fact set to adopt it or not. Nor does the state's reliance on out-of-state authorities in which personas other than the decedent are targeted and or injured support this proposition. This again it's not entirely dishonest, but it's got some dishonesty to it because the reason the state doesn't have this case is, like they said, Utah hasn't adopted it. But notice what they aren't saying. Utah also has not rejected it. We know they haven't rejected it because they would have cited that case in here. And if they don't, it's malpractice. So they definitely would have. So while they're saying the state's relying on out-of-state authorities, they have to go out of state. There isn't a comparable case in Utah that they can draw. As a matter of law, the court cannot bind Mr. Robinson over on his theory of the KGRD aggravator based on the facts presented by the state. So this actually is not as a matter of law. This is incorrect. This is an improper state. I mean, it's not like malpractice, improper, or perjury. It's just an improper argument because as a matter of law, they just said above, the Utah court has never adopted this, and they didn't provide any example where the Utah court has rejected it. In fact, I don't know that they provided any examples where the knowing great risk of death was actually rejected. The state's anyone near argument similarly fails both factually and as a matter of law. The state's second argument in support of the aggravator is that the shooter knowingly created a great risk of death to everyone near Mr. Kirk when a single shot was fired. The state's argument here also fails because it requires the court to speculate in the absence of evidence that would otherwise permit reasonable inferences. That's not true. Moreover, the state's argument fails again as a matter of law because the conduct here fails to satisfy any of the 3 factors in the Utah Supreme Court has held must be present in the order for the KGRD aggravator to be pursued in a manner which does not violate defendant's constitutional rights under the 8th and 14th Amendments. Okay, so they're saying it fails as a matter of law, or fails the absence of evidence that would otherwise permit reasonable inferences. What they're referring to here is they have no evidence of Tyler's state of mind. So the court has to speculate on the state of mind. But the inference is the state of mind. His state of mind is inferred by him pointing a gun towards a person in a crowd of people. That's the inference that the state is asking the court to draw. Is that a reasonable inference? I tend to think so, but again, it might not be also. You could see where that one could go either way. I think the court will say it's reasonable. Hedy Lamar says, Nick, what the fuck are you reading? This is Tyler Robinson's memorandum or his briefing related to his probable cause hearing that he just had. This was filed yesterday in the biggest political assassination case in my entire life. Well, Bobby Kennedy was killed while I was alive, so maybe that one's different. But other than that, this is the biggest, and this might be bigger than that. In this case is this is present shit on the edge. It was filed just early morning yesterday. So now we've got knowledge. So we're on to a separate thing here. The state asked the court to make a finding that the shooter knowingly created a high probability of grave risk of death based upon speculation that is not supported by the evidence. The state speculates and asks this court to speculate. So here's their allegations that these are not inferences, that this is speculation. That the shooter actually observed security personnel standing an unknown distance from Mr. Kirk. So they're arguing that because there is, and of course we know that since Tyler Robinson hasn't made a statement about these things, and he hasn't testified and can't be required to testify, they're saying that these cannot be inferences, that this is speculative. But it is an inference that when looking and lining up the shot for Charlie Kirk, it's inferred that he would see the security personnel. Also, it's supported by the other evidence, the totality of circumstances. Remember, this is totality of circumstances. He knows there's a bunch of people. In fact, he was down talking to TPUSA, like allegedly talking to TPUSA recruiters or something, right? Beforehand. Allegedly, he walked around the campus. He would know, this is the inference, he would know that there are people all around that area, security personnel and others. He likely saw security personnel during all of this. And again, what the defense is asking here, they're asking the court to pretend that Tyler Robinson didn't look towards Charlie Kirk at all, that he got the rifle out, pointed it that way, and then only looked through the scope. And while looking through the scope, he only saw Charlie Kirk. That's the inference or speculation, I would say, that they're asking the court to draw. The reasonable inference is that in lining up the shot with his rifle, that he looked towards Charlie Kirk, probably outside of the scope and then probably inside the scope, and almost certainly saw other people near him. This is not a good argument here. That the shooter may have known that there were people behind the pop-up tent when the single shot was fired, although the state's evidence actually shows otherwise. So again, this is about the shooter's state of mind. This aggravating factor is not about what actually happened, right? This is about whether the shooter did something that put people at risk. They say he doesn't know, or that the state's evidence shows otherwise because there wasn't someone at the moment of the shot. I don't really think they need someone back there at the moment of the shot anyway. There's people close enough by. That the shooter knew that they may strike someone other than the intended target because there were 4 cartridges found in the rifle. This is a leap that I don't know that the state actually asked them to make. I don't find this to be truthful, but maybe the state made that claim. I think the more likely thing is the state said that the 4 cartridges were indicative of the possibility he would miss, which supports the third factor, the stray or the ricochet. If he misses Charlie Kirk with the first shot, he has 3 more shots he can take. That the shooter knew that they may strike someone other than the intended target because targets with bullet holes in them were recovered from Mr. Robinson's shared apartment. Well, yeah, this is dumb. The inference is that he would know that he won't always hit the bullseye, right? Like that's the inference from the targets that have misses. That the shooter knew they may strike someone other than the intended target because the rifle may have been taken apart and put back together. These assertions are not reasonable inferences from the evidence actually presented, and in one instance are actually inconsistent with the evidence before the court. The evidence does not support that the shooter acted knowingly. That is, that the shooter was aware that there was a high probability that someone else may die from a single gunshot that hit his intended victim. And this is a little dishonest, right? One, because it is entirely possible that the round would have gone right through Charlie Kirk and hit someone else. That's possible. It's feasible. It's inferable. Although it's speculative that that would happen because it didn't happen. It is possible that it could happen. But this is a misnomer, I think is the right word or expression for it. It's not, he doesn't have to think that the round that hits Charlie Kirk could cause the death of someone else, even though that is a possibility, right? But he doesn't have to think that. He has to think that him pulling the trigger in the first place and firing a round in the direction of Charlie Kirk could hit someone else. That's the difference. That's where they're wrong on this one. As to A, the state's evidence shows that the presumed shooter was on the low-C roof in a prone position for 35 to 44 seconds before firing their weapon once. According to the state's evidence, this means that the shooter had approximately 40 seconds after coming to rest to ready their rifle, acquire the target. This is language that this is the language that undoes the argument. How do they acquire the target? Right? If you have the target, you don't have to acquire it. If you have to acquire it, it's reasonable to infer that you're looking at something other than the target, which means it's reasonable to infer at that point that you see somebody other than the target. Even if he doesn't look anywhere else, he only looks through the scope. They admit that he had to acquire the target with the scope on the rifle, because there's no way he points the rifle blindly and automatically is aimed right at Charlie's head. That didn't happen. That wouldn't happen. It's much more reasonable to see, for him to take a second to aim. Steady their breathing and fire the weapon. I don't know that this is in evidence. We don't know that his breathing was steady. So they've just now added speculative facts that steadying their breathing was part of what he did. We don't know that about Tyler Robinson, I don't think, unless it's in the text, but I don't think it is. The state asked the court to speculate about what the shooter saw through the scope. Maybe this is something that's in the state's filing. I don't know. State asked the court to speculate about what the shooter saw through the scope during this limited window of time while focusing on these tasks. No, they're not asking to speculate. They're asking to infer reasonably that he would have seen them. However, one of the state's case agents, Agent Hall, testified he could not testify as to what the shooter saw. Of course. Indeed, the only reasonable inference from this limited time window and the fact that Mr. Kirk was shot was that the shooter observed Mr. Kirk through his scope. This is taking the argument too far. This is taking the argument too far. That is not the only inference that you can draw. You can draw the inference that prior to pulling the trigger, he saw Charlie Kirk, right? Because assuming he's shooting Charlie. But that's actually a little speculative too, because maybe he wasn't shooting at Charlie Kirk. Maybe he was shooting at someone else and just missed really bad. Maybe he's a big Charlie Kirk fan. Maybe he's trying to kill the Jews that ultimately killed Charlie Kirk. Okay, as to B, the state's assertion that the shooter would have known that there were individuals behind the pop-up tent is not a reasonable inference supported by its own evidence. In fact, State's Exhibit 9 shows no one directly behind where Mr. Kirk was located when the single shot was fired. But he wouldn't know that. He couldn't know that. He does know that there are people in the area. It's reasonable to infer that he could be firing, not caring if it missed and hit someone behind him. Moreover, the shooter could not, of course, see through the tent and again was on the rooftop vantage for only 35 to 44 seconds before taking a single shot with a high-powered rifle with a precision scope attached to it and then immediately fleeing back to the rooftop area. So again, the high-powered rifle with a precision scope. This is their argument, is that he killed Charlie Kirk really specifically and no one else. State relies on surveillance footage from earlier that day and September 10th to suggest that the shooter had knowledge that there would be people behind the pop-up tent during the event. This is what I just kind of mentioned. The state's evidence is that Mr. Robinson was on campus at 8:30 a.m., went to the amphitheater at that time, 3.5 hours before the event began. The state asked the court to speculate that the amphitheater and the people around it looked to the shooter at the time as it did just 4 hours later when the shot was fired. And again, this is unreasonable. No, it didn't look the same. It would look more crowded. There were more of a crowd 4 hours later during the talk than there would have been at 8:30 in the morning. Again, this is one of those things where maybe you think this sounds smart, but when you apply any sort of practical thought to this, it undermines their argument. Because there would be more people, more densely packed at the time he took the shot than when he was there at 8:30. As depicted in States Exhibit 6, 7, 8, and 9, there is no evidence from which the court can make such an inference. And again, the evidence is that the shooter had an extremely narrow window of time to observe the intended target through the scope of the rifle. Hey, let's wait 40 seconds. Oh, we're halfway there. Whoa. 30 seconds. Forty seconds. 40 seconds is not short. 40 seconds is a long motherfucking time. They're saying that in those 40 seconds, he wouldn't have had any possibility of seeing anybody else. That's the only reasonable inference. Crazy talk. Crazy talk. Let's see. There's no evidence from which the court can make such a claim, an inference. And again, the evidence is that the shooter had an extremely narrow window of time to observe the intended target through the scope of the rifle. The only reasonable inference that can be drawn is the shooter saw the intended target. As to C, the state asked the court to speculate about the shooter's knowledge that he was creating a high probability that someone else could be killed because the recovered Mauser 98 had more than one round of ammunition in it. This is a circumstance in which the state cannot prove one inference is more likely than any other and is thus asking this court to speculate. Again, that's not what speculation is. That's what speculation is in this Cristobal case, which I'm betting they applied improperly. It is just as likely that the shooter did not believe he would miss as it is that the shooter believed as the state speculates. All reasonable inferences fall in favor of the state at probable cause. Having two reasonable outcomes means the reasonable inference is the state's. It's not speculation at that point. Having a loaded weapon does not mean that the individual believes there is a high probability of missing and killing someone else. It only means that they have the ability to fire more than one round. The facts here are that the shooter did not miss his intended target and did not chamber another round, leaving the spent cartridge in the rifle. So again, this is an attempt at a sleight of hand or sleight of tongue, as it were, because they're saying because he brought 4 rounds and he hit the target, therefore it's not reasonable to infer that he thought he would miss. Sorry, that's not deductive logic. And this is specifically deductive logic. The deductive logic is that 4 rounds that are all engraved, by the way. It's not like he put the 1 engraved round and then 3 unengraved rounds. All of them are engraved, are in there. The deductive logic is that he wanted to have the opportunity to take more than one shot if necessary. That means that he had to consider that he would miss. Not that he planned to miss. he had to consider the possibility that he might miss, because of course you might miss. Actually, I've seen tons of videos asserting that this is an impossible shot that only a highly trained super Jew sniper could pull off, which is nonsensical assertion as to that. But that's, a bunch of people have claimed that, including, I think, Baron Coleman and Candace Owens. As to D, the state argues that the targets taken from Mr. Robinson's apartment support an inference that Mr. Robinson used the targets in connection with the shooting at UVU and therefore knew of a high probability of a risk of death to others. I think the first part is using the targets in connection with the shooting. I don't know that that's supported. It's reasonable to infer that he used the targets to sight the rifle, to adjust the scope, right? That's a reasonable inference from those targets. But it is not automatically reasonable to infer that the sighting of the rifle is for the purpose of killing Charlie Kirk. You can understand why someone might sight a rifle and not kill Charlie Kirk. People do that all the time. Well, now they have an excuse. But you know what I mean? Like you want to sight in your rifle. He may have subsequently decided to kill Charlie Kirk. Now, there may be some text messages that, under the totality of circumstances, I don't have encyclopedic knowledge of the text messages. I know he said something like, looks like grandpa's gun did the job, which that then, if there's another message that says, glad I went to the range and practiced this, glad I adjusted the scope, et cetera, et cetera, et cetera, like then you start to build it under that totality of circumstances. I don't know. I think this is a good avenue of attack, but they don't have to win one of them. They have to win all of them. So, okay. However, this court cannot reasonably infer that Mr. Robinson's alleged use of the targets at some point in time in the past with some unknown weapon led to such knowledge on his part. I agree. The state presented, unless there are text messages supporting it. But other than that, and I don't know, I'm not going to say there are. I'm just saying that would be the only way. The state presented no evidence of when the targets were used, what weapon was used with the targets, the conditions under which the targets were used, or even that Mr. Robinson was alone in shooting at the targets, i.e. that all the target shots were fired by him. Without any evidence tying the targets to the seized weapon, the relevant time frame, and the conditions under which the targets were used, targets are not a basis for any reasonable inference about the shooter's state of mind. This is their most effective argument I've seen so far. Again, it doesn't win. They have to win all of these. But this one is the best argument. But there may actually be evidence that I'm not aware of that would be like I said, the text messages. If he talks about sighting in the rifle, glad I did that so I could make sure I would hit Charlie, something like that. You can see how that would be it. But again, I don't know. I don't remember. As to E, the state also asked this court to speculate that after scoping the rifle, it was taken apart and put back together prior to the shooting, and that therefore the shooter knew that a lack of accuracy created a high probability of risk of death to others. The state presented no evidence to support any inference that the rifle was in pieces at any time. Here we go. This is going to be fun. So they're going to claim the rifle was not disassembled and reassembled. I love their reasoning for why they're going to do that. But I would actually argue that the state did present evidence to support an inference that the rifle was in pieces. One, they assert that the rifle pieces were in his pants. Two, they assert that they found a screwdriver. And I believe that it's of the type that you would use to complete the reassembly. They found the screwdriver up on the roof. Is that required? No. Is that the automatic outcome? No, I don't know that this is the most ironclad claim of the state, right? Like, I don't know that it is. But I think the state may have other evidence they present at trial, et cetera. But here's the thing. The rifle doesn't need to be in his pants. or need to be disassembled in his pants. It doesn't have to be. It could be. And we don't know that he transported it in his pants. He could have stashed the rifle in parts at different times. You know, there's weird other things that could have happened. We don't know. Doesn't really matter in the grand scheme of things. But I do agree that there's nothing specifically that says taking it apart and putting it back together would automatically create lower accuracy. I've seen people claim that online, that him taking it apart and putting it back together would be useless because it would create, it would completely defeat the sighting in of the rifle. I don't think that that's accurate, honestly. I don't think that disassembling and reassembling, which it's basically like breaking it down into two parts. It's like removing the stock, I believe, right? I don't think that removal of the stock automatically makes the disassembly into a thing where he can't make the shot. But I don't, if the state made this argument, I don't agree with it. The video evidence shows Mr. Robinson walking up and down stairs at UVU with a gait impaired by something long in his pant leg, which is why I propose we rename him Tyler Donginson. Because my man is walking with a hog. Tape it to your ankle, big dick. Jesus. No wonder Lance likes him, right? The reasonable inference from the evidence provided is that it was a fully assembled rifle. And then they compliment their boy and then they shut him down. It's like, no, that's not a dick in my pants. It's actually a Mauser. The presence of it, you know, you could probably pick up a German chick if you said you got a Mauser in your pants. Like, I'm betting you walk with a limp, your legs stay straight, you never bend the knee. Like, what are you doing, big boy? Oh, I'm sorry, I got a Mauser in my pants. I bet you're in the bathroom in about 12 seconds getting pegged. Okay, so the presence of a screwdriver on the roof does not establish that the rifle was taken apart and put back together any more than it establishes that the screwdriver was intended to take the rifle apart after the shooting. I agree with this statement, but the reasonable inference goes both ways, which means it goes to the state's way. Although I'm not fully aware of the details of the screwdriver and the rifle and the scope. Is it possible, and this is just speculation on my part, is it possible that the screwdriver is there to adjust the sight, the scope, right? I know that some scopes have like hand dials that you can turn, but other ones have like a more precise thing, right? Like you put a flathead in there and turn them. Like, am I crazy? I'm pretty sure that's true. I'm pretty sure that was true on the rifle that I had with the scope. But I might be wrong on that. Like I might be misremembering things. The state did not present any evidence to show as to how the screwdriver could have been used to disassemble and reassemble this weapon in the period of time at issue. Well, there's like a 7-minute gap in the video. And I think the state has said basically that he assembled it during that gap. But I'm not sure. Even if the court draws the inference that there is a connection between the rifle and the screwdriver, the court cannot then reasonably infer from the inference that a rifle deconstructed and then reconstructed would be less accurate, let alone that the shooter knew of that risk. The way they present the argument, I agree with them. I think they're overlooking some things personally. The state cites to this reference to support this assertion. The testimony from Officer Bagley here is a red and black screwdriver was observed 10 or 15 feet in from the other side of the guardrail in the gravel. There is no development of the state's theory in this testimony. So basically that there was a screwdriver, like, so the idea, not saying this is the argument to the state, I'm not going to give them credit for something that they seemingly haven't done, but the speculative idea would be that he assembled the rifle, dropped the screwdriver, went over the guardrail, like he just completely forgot it. Or maybe he put the screwdriver into his pocket or in with the towel and then it fell out. Who knows? Presence alone is insufficient as a matter of law to show a knowing great risk of death. Okay, so the knowledge aspect they've attacked, I think they are successful on a couple of those. There's 5 of them. I think maybe 2 of them, maybe 3 they knock out, but they got to knock out all 5. They have to knock out all 5 arguments to to defeat probable cause. And I don't think they do. Different for trial, right? Different for trial. So even assuming arguendo means for the sake of argument, that the shooter had knowledge that there were other individuals near Mr. Kirk, this fact alone does not satisfy that there was a great risk of death to another. The state relies on cases from Pennsylvania for the assertion that a zone of danger encompasses everyone near a shooting victim. Yeah. Yes. As noted above, Utah has never adopted a formulation of knowing great risk of death under which a single gunshot fired at a specifically identified target who is near others is sufficient to establish it. That doesn't mean they have adopted something narrower, though. Moreover, the cases cited by the state from Pennsylvania, again, do not support its position as explained below. You already explained it above. Why are you going to do it again? In Rios, 3 assailants entered a home to commit a robbery. The residence was occupied by 4 individuals. 2 of the individuals were beaten and multiple firearms were involved. All 4 of the victims were forced to lay down either on a bed or on the floor in a single bedroom, and one of them was shot and killed. The court found that the facts presented at trial supported the knowing great risk of death finding because the fatal bullet was fired while the victim lay on the floor of an enclosed bedroom, with one individual on the floor close to the victim and the others on the bed nearby. Holy shit. That case, again, this is coming from the Commonwealth of Pennsylvania, so it's not binding on Utah, but it's informative. That case is extremely supportive of this. 1 shot, 1 kill. The other people are nearby, one on the ground and on the bed. Okay. But the shooter is really close, right? Like, so you can, I would imagine, I guess I don't know. I think they would say if the shooter was far away, but you would imagine if they've got them tied up on the floor and they're going to shoot one of them, that they're probably pretty close and they just shoot the one they want. Okay. In Commonwealth versus Lie, the court upheld the finding of grave risk. Notice these more upholdings, although these, in fairness, I think these were raised by the state and they're addressing those. Grave risk when 3 assailants with multiple firearms shot 1 individual in the head inside the kitchen of a restaurant while the murder victim's sister was standing directly next to her. 3 assailants with multiple firearms shot 1 individual in the head. Now, it doesn't say that the 3 assailants with multiple firearms took multiple shots, which is why the state would use this. The state is using 1 shot, right? 1 shot, 1 kill cases, something that the defense should be using, but they don't have any. In Commonwealth v. Smith, Commonwealth presented medical and forensic evidence to demonstrate grave risk of death to another person. The evidence demonstrated that 4 shots were fired by the defendant. Okay. The first shot fired hit the victim, who fell but then tried to get up. Thereafter, the defendant fired 3 more shots at the victim. 3 of the rounds lodged in the victim while a 4th passed through. One of the bullets fired at the victim ricocheted off a solid surface before hitting the victim. There were several people on the porch in very close proximity to the murder victim at 260. The Pennsylvania Supreme Court affirmed the finding by the jury on these facts. So what is very close proximity? We don't know. We don't have a few feet. This one, all the rounds strike the person. There's no indication of anyone else being targeted, and there's no indication of anyone else being struck. Again, you can see why the state picked this case, especially because 3 of the rounds are lodged in the victim. 1 passes through. One of the bullets ricochets and hits him. So like you can see all of the things the state has been pushing are encompassed in this case, even though it's 4 shots instead of 1. In Commonwealth v. Wright, the evidence supporting grave risk was that Wright broke into a small bedroom while swinging his loaded gun in all directions, then put his gun to the victim's wife's head. Once finding the victim, Wright fired 5 shots at him, 3 of which went through him and 1 which was never located. The victim was only a few feet from the bed on which the child was laying, and the shell casings were found all over the bedroom. Pennsylvania court determined that under these circumstances, it was proper to leave grave risk of danger determination to the jury. Yes, obviously. Again, not a good case for and of course, the state picked these cases. They're not going to be good for the defense. The significant factual differences between these cases and the case before this court are plain. Are they? Are they really plain? The bullet that struck and killed Mr. Kirk was not fired in an enclosed bedroom or space. What does that have to do with anything? What in the fuck are you talking about? But rather an open air arena with what the state's witness termed a clear line of sight. There were no threats to others in the course of conduct. And again, this is to say that it is known, not even that he knew, that it is known that he would have struck his target on the first shot and no one else is at risk. This is, I can't think of a court that says that there's someone sitting right next to Charlie, by the way, within 5 feet, sitting within 5 feet of Charlie, that person's not in the zone of danger from a rifle shot fired at 147 yards. I can't think of any court that would honestly say, oh yeah, that guy's out of the way. Okay, so here we go. There was no one directly next to Mr. Kirk when he was shot. I mean, there was someone, right? How close is that person? Does anybody have video? Locals, locals, you're posting great pictures. Do any of you have the picture of where the guy was sitting next to Charlie Kirk when he was shot? I don't want to look it up. Okay, so here we go. There was no one directly next to Mr. Kirk when he was shot, and there were no one under the tent on the side that Mr. Kirk was struck or behind him in the breezeway. Multiple shots were not fired. Now, they have to ignore the fact that there was someone next to him on the other side. Multiple shots were not fired. There were no ricocheting bullets. Again, they're trying to skip the step of, could a ricochet hit someone? They're saying there were no ricochets. Yeah, but what if there was? What if you did eat breakfast? Per Dika says, I think the guy with the camera to the left of him was within 5 feet. Yeah, I think so too. Dragon Wizard God has rated the stream on Rumble. What's up, Dragon Wizard God? Welcome to you and your friendly peeps. So let's see, these cases from a state with a moratorium on its own death penalty. This is irrelevant, by the way. A state putting a moratorium on its own death penalty, assumedly legislatively, still has the death penalty, and it still has all of the legal common law around the death penalty factors. Are not Utah law and do not support the state's call for this court to adopt out-of-state authority that vastly expands the aggravator beyond its constitutionally narrow application. This is, again, a misstatement or an overstatement. This doesn't vastly expand the aggravator beyond its narrow application. They would find it within the narrow application. It's not an expansion just because they don't have a case on point. The expansion would be if they had a close case and they didn't adopt it, and then expanding it by adopting it here. That's not what's going on. That's why it's an overstatement. As explained in Sosa Hurtado 2, Johnson and Pierre, Utah law requires this court to look at more than mere presence and determine there is a high probability, not a mere possibility, that another would be killed by the shooter's conduct and that the shooter knew of that high probability. This is all great, except for this is probable cause. So that mere possibility, high probability thing, that just is going to be resolved by the jury. That's a fact question. Are people close enough to be in danger? We're going to have expert testimony. They didn't do the math. If they would have done the math and shown that there was no possible way that the questioner was in the line of fire, I would have done that. I would have put the math in the brief. Here's the triangle. Here's a little diagram that shows that the bullet could not have touched this guy or anybody else. Why not? Why isn't that in here? A plenary of jurisdictions. A plenary? I don't know that that's the right term here. Of jurisdictions support Utah's narrow construction. Again, if this is found, it's not going to be an expansion of the construction. It'll be within the narrow construction. Many other jurisdictions have interpreted the factor as the Utah Supreme Court has, a multi-factor analysis that examines the course of conduct of the defendant and actions toward the another in determining both the defendant's knowledge and probability of risk. For example, Oklahoma has determined the evidence is sufficient to support it, where the defendant created a great risk of death in close proximity in terms of time, location, and intent to the killing, or threatened the life of another and had the apparent ability and means of taking the person's life. Okay. In the rare instances where the person at risk was not actually injured, the defendants in those cases seriously considered killing people other than the actual victims. So they're going to out-of-state authority now, and which is distinguishable because Utah does not have this serious consideration factor. They don't have it, but they're going now right after complaining. And again, it's not a problem. I don't like it. It breaks the theme of the drafting. If you're going to say going to out-of-state authority that's not congruent with Utah authority is wrong for the state, then it's wrong for the defense. In the Oklahoma case of Little John versus State, the court considered the sufficiency of the evidence supporting the factor. The court found the evidence was insufficient to support the factor where the prosecution presented no evidence that defendant considered injuring anyone other than the actual victim. So again, Oklahoma seems to have this consideration factor, which isn't the same as Utah, but they're pushing for it. It's not a bad idea, by the way, but it's probably not going to happen at the district court level. Although defendant pointed a gun at a clerk when he asked for the store's money, this act was driven by defendant's intent to rob, not to shoot. Additionally, only a single shot was fired and it hit its intended victim rather than endangering anyone else present in the store. As summarized, this is not a case where the defendant shot wildly into a store or a crowd. Only one shot was fired. The shot hit its intended victim. Now, you guys, are you noticing something? The single shot did not endanger anyone else present in the store. Consequently, under the specific circumstances, we find the evidence was insufficient to prove it. They probably borrowed the intended victim, the single shot. They probably yes, it's the facts of this case, but the language that they use, even though we only have this tiny fragment of a paragraph, the language that they use here, largely congruent with this citation. I bet they borrowed a ton from either the briefing or the decision in this case. So rejecting Eighth Amendment vagueness challenge to knowing great risk of death because reviewing Oklahoma case law, Oklahoma courts provided consistent guidance in the jury as to limit its discretion. Okay. Wyoming Supreme Court upheld it in Engberg versus State, concluding in shooting errantly at persons in parked vehicles in the lot, Engberg manifested an utter disregard for lives of innocent persons. This evidence demonstrated beyond a reasonable doubt that he knowingly created a great risk of death to two or more persons. Olson versus State addressed another bystander case. The Olson court noted that the state failed to produce evidence or suggest that there were other bystanders involved who were threatened with grave harm as Olson shot his intended victims. Thus, strictly construing the Wyoming statute, the Olson court found the use of the terms risk and persons was given its proper application in Engberg's factual situation by placing bystanders in a parking lot at great risk of death by errant shooting. In the Alabama case of White versus State, the appellate court held that the finding of knowing great risk of death, and again, all of these upholding ones, I know they're trying to distinguish them, but all of them weigh against, they all weigh against their own argument. Any finding is bad for them. They have a couple from Oklahoma. Those were good. Let's see. The defendant indiscriminately fired a shotgun into an occupied dwelling containing not only the victim, but two other people. And the defendant fired the pistol out in the front yard in a residential neighborhood where many other people were present. Court found the defendant's conduct in the indiscriminate firing of these weapons did in fact create great risk of death to many other people. Finally, that doesn't sound like those people were actually in proximity. So that might not be the best case when you get into the nitty gritty. Emmy says, thanks for giving me something to listen to while at work. Much love to you in chat. Much love to you, Emmy, and your beautiful 7-month member. Wonderful. Todd Davis sent Uncle Alert. Thank you, Todd Davis. And D. What gifted a membership. Thank you, guys. We are up to 27 memberships for the stream. That is beautiful. That is beautiful. Okay, so finally, there's also an almost identical federal statutory aggravator. Okay, this is interesting. See, here we go. This is something good. Mr. Mike, I see your chats. We'll get to them in just a second. almost an identical federal statutory aggravator, 18 U.S.C. 3592 C5. Defendant in the commission of the offense or in escaping apprehension for the violation of the offense knowingly created a grave risk of death to one or more persons in addition to the victims of the offense. This is actually a little bit more broad because it also allows something like if you're escaping and you hit someone with a car, or if you drive recklessly. In United States versus McVeigh, the Oklahoma City bombing case, the district court found the inclusion of knowing great risk of death in the indictment was proper. Well, yeah, he put a big fucking bomb in front of an FBI building where the government intended to prove that the truck bomb was of such force as to create a risk to persons who were not physically affected by the explosion. Similarly, in U.S. versus bin Laden, another bombing case where oh my God. The district court sanctioned the inclusion of knowing great risk of death as an aggravator, noting knowing great risk of death relates to defendant's mental state with respect to persons who were not the intended victims of the bombings. The bin Laden court noted there may be a qualitative difference between a defendant who carefully targets an intended victim or victims without endangering others and one who acts with indifference to additional persons. So again, he only killed Charlie Kirk. I said they. Fuck. I'm sorry. The Jews just reduced my money by $1,000. So we have see also, these examples are non-exhaustive. See also State versus Johnson in Missouri, upheld the jury's finding of the factor where the defendant shot a law enforcement officer multiple times and a bullet struck a juvenile standing next to the patrol car. State versus Hazleton in Kansas, upholding where defendant lured two victims to the woods, intended to shoot both, shot one, and shortly thereafter shot the other victim, demonstrating a course of conduct. Yeah. And then State versus Carver, trial court did not err in finding knowing great risk of death. Oh, that's nice. But they're non-exhaustive, but they illustrate how other jurisdictions have interpreted it consistently with the Utah Supreme Court. But so did the other jurisdictions the state brought up, like Pennsylvania. These jurisdictions all require close examination of the defendant's course of conduct and the mental state of the defendant relative to the other individuals. Yeah, but they put extra restrictions on. They're more restrictive. Count 6 must be stricken. So now, okay, we're finally past the aggravator. That aggravator. These are other aggravators. But that aggravator is done. So that was the conclusion of that whole thing. Okay. We're on page, what? 27. I just want to point out something I mentioned earlier. Note the difference in the argument on the aggravating factor and the overall murder. Argument on the overall murder was 3 short paragraphs. And that's being generous. The argument on the first factor was 25 pages. They don't even fucking argue. Again, they're not arguing probable cause here. They're not arguing probable cause on the underlying murder. Okay. Emmy gifted 5 memberships. Thank you, Emmy. Thank you very much. That brings us to what? 32 memberships. Very cool. Nice to see that. So Mr. Mike says, by the way, this doesn't mean the defense, are conceding authenticity or foundation or any other argument that goes to its admissibility at trial. Andrea Burkhart. Yeah, I know. I didn't say they were. You might have missed earlier, and it's okay if you did, but I said earlier that this does not create a factual foundation for trial, but it gives us an idea of the defense's posture going into trial, which they are going into trial. One thing that Baron Coleman and Candace Owens and Stu Peters, Ian Carroll, Lionel Media, what they don't want you to remember, they don't want you to recall, is that they have said over and over that the state cannot, has not, did not produce enough to proceed to trial, that they failed at probable cause. They first said they would fail at probable cause. No way could they show it. Not a chance. They then asserted that they weren't showing it during the hearings, and then they asserted that they didn't show it later. Probable cause is overwhelming in this case. Overwhelming. The defense knows it's overwhelming, which is why their argument is hyper focused on a couple of the aggravating factors around the death penalty. Now they're going to say, of course, oh, probable cause is easy, low bar. And they gave their little warnings ahead of time. Yeah, probable cause is a low bar. But even then, they can't do it. They can't support the facts. They can't do it. They did it. They didn't do it. No. Weak case. And then the defense comes out and doesn't use any of their arguments. Baron Coleman highly emphasized the timeline of the messages. The defense adopted those messages happily because they need to fight the death penalty. They happily took on those messages. They don't dispute them for the purpose of probable cause. Those messages, again, those text messages and Discord messages place Tyler Robinson as the most likely person to be on the video. They're also, admissions in and of themselves. The admission of those text messages, which Baron Coleman assured everybody happened after Tyler was apprehended, or after he turned himself in and his phone was taken. He couldn't have made them. They're faked. The defense makes no effort. In fact, the defense relies on those messages in its anti-death penalty argument. Is it a concession for those messages' admissibility at trial? No, the admissibility will be determined by the trial judge. They're admissible. They're party statements against interest. They could have raised authenticity questions. They didn't really do very well on that. They could have said these were faked. Here's the timeline. It's not possible for him to have sent these messages. They didn't do that. Why is that? Because that's wrong. It's been wrong the whole time. People have tried to point out that it's wrong. Some people tried to say that's not true. Testimony is that he turned himself in at 9 o'clock. And I think the Discord messages were around 8:30, saying, I'm about to go turn myself in. And then he did. And then everything that's said in the text messages is exactly what happened. And all supported by the evidence. The defense doesn't concede anything, but they do concede that their posture here is mitigating the death penalty and not trying to win the case. They know they're not going to. Anyway, that's to address that. And then he sent, check this out, multiple angles and on topic. He says, oh shit, damn it. Okay, no, I'm not gonna do a video. I can't on a live stream if the gun is shown or Charlie's shot. Like I can't do that on a live stream very well. That serious risk of getting immediately banned. He says Lionel said it was going to trial 6 months ago. He's a former prosecutor. He's kind of changed his tune since. You got that wrong. Wait, where did I get that wrong? He's saying the state should have went to a grand jury and saved a lot of time. The state doesn't need to go to a grand jury. They have a probable cause hearing. Why would he say that? How does going to a grand jury save a lot of time? Also, how does he figure going to grand jury saves time? It saves public time because grand juries are secret generally, right? But it doesn't save time. Like they'd still have to do the grand jury hearing. They'd still have to present probable cause to a grand jury, but they don't need to. What a silly thing to say. Count 6 must be stricken because the evidence does not establish that Mr. Robinson's statement to Mr. Twiggs to ask for a lawyer and stay silent was intended to obstruct an investigation. So count 6 is obstruction of justice. Count 6 charges Robinson with tampering with a witness in witness tampering, violation of Utah code. The information alleges that Mr. Robinson committed this offense by directing his roommate to stay silent if police question the roommate. I think this is a weak charge in general. Hey man, don't talk to the cops if they ask you anything. I don't think that's obstruction of justice, honestly. Like it shouldn't be if it is. The state alleges that by telling Mr. Twiggs to exercise his right under the Fifth Amendment to the United States Constitution to ask for counsel and to remain silent, Mr. Robinson attempted to induce or otherwise cause his roommate to withhold testimony or information with the intent to prevent an official proceeding or investigation. Now, I don't know that he says to exercise his, he says, don't talk to the police if you're questioned, or I guess directing his roommate to stay silent. I guess I'd have to look at the language, but I'm with the defense on this one. I don't think that's obstruction or witness tampering, in my opinion. Unless he said it along with a threat or but I think the problem is he said to destroy the letter, right? I think that's maybe more of the thing, destroy the letter, delete the texts. That to me is actually, that's where the witness tampering is. Because by asking him to destroy the text, he's asking Lance Twiggs to destroy evidence in a criminal case. That's where the witness tampering comes in my opinion, much more than the stay silent. So I think they might be overstating that one a bit. Count 6 must be stricken because Mr. Robinson's advice to Mr. Twiggs is consistent with the long-standing constitutional principle that every person in this country has the right to remain silent. They have the right to remain silent. They don't have the right to delete text messages when there's anticipation that they're part of a criminal trial, and they don't have the right to destroy a letter that would be evidence in a criminal trial. They don't have that right. In the face of government interrogation, and because the context in which the allegedly improper statement was made demonstrates that it was purely altruistic and for Mr. Twiggs' benefit rather than for the purpose of obstructing an investigation. I don't think they can actually sustain that argument, though. So this footnote is just a continuation of the one where it's like going through all the different cases. I'm not going to keep reading that. Where the inducer's motive in advising another to remain silent is to impede the investigation against him, rather than give purely altruistic advice, he is obstructing justice. That's U.S. versus Peterson. I don't think there's any way they can sell that Tyler Robinson told Lance Twiggs not to talk to the cops for Lance's benefit. I don't think that's true at all. Not solely for Lance's benefit, if nothing else. Maybe for Lance's benefit a little bit, but more so, I think, for Tyler's obvious benefit. So they're going to lose that one. I agree with them in principle, but under the rule, they're going to lose. The inverse is therefore true where the advice is purely altruistic. One is not obstructing justice. Mr. Robinson's advice to Mr. Twiggs was as follows. And again, this is why they want those messages, right? If any police ask you questions, ask for a lawyer and stay silent. My lawyer should be Doug Terry. I'll see if he can reach out to you and make sure he can't do that. Make sure the police follow the right procedures, proper warrants and stuff, but be polite and respectful, of course. See, this advice is fine. In my opinion, again, this is fine layperson's advice. Although I don't think that it's purely altruistic. I think that standard might be too harsh, even though that's the rule. But I think it's combining that with the delete these text messages now and the destroy this letter. Okay, whether an individual who is under investigation is obstructing that investigation or providing truly altruistic advice to another requires a context-specific analysis. Here, the conversation between Mr. Twiggs and Mr. Robinson demonstrates that Mr. Robinson's focus was on protecting Mr. Twiggs from any fallout from the events which had transpired, and not on inducing him to obstruct an investigation. He says to Mr. Twiggs, I'm going to turn myself in willingly. One of my neighbors here is a deputy for the sheriff. Fuck. We hope to keep things sort of quiet here. I only hope they let you visit. I'm going to miss you too. Please be good for me. If you need anything at all, both of my parents are willing to help you. Please go to them. Leave the room alone. The feds will search it top to bottom for certain, then work with my family to sort it out, what goes where and such. In response to Mr. Twiggs's question, is there any way you don't go to prison? Mr. Robinson responded, I highly doubt it. I will update you as much as I can. If you need a place to stay, I'm sure my family would have you in my old room. By the way, this would all be presented as evidence of witness tampering. Hey, don't worry about it. I got you. My family's got you. Don't say anything. Don't mess with anything. Let the lawyer sort it out. You need a place to stay. My parents got a room for you, bud. I'm going to miss you. I love you. They would say this is all evidence of witness tampering. Like this would be quintessential witness tampering evidence support, but they need the underlying linchpin, right? The ask. So, if you need a place to stay, I'm sure my family would have you in my old room even. You are all I worry about, love. Don't talk to any media, please. Don't take any interviews or make comments. I will always love you too. I will write you as often as possible. I wonder if that's still true. If any police ask you questions, ask for your lawyer and stay silent, or ask for a lawyer and stay silent. Make sure the police follow the right procedures, proper warrants and stuff. Be polite and respectful, of course. Again, they are ignoring the very important context of delete these texts. That statement to delete the text, delete this conversation, which they haven't brought up here, but that's in there. I remember that one. That's the context that matters. These statements by Mr. Robinson contextualize his altruistic advice to Mr. Twiggs to exercise his rights under the Fifth Amendment, to ask for a lawyer and stay silent. The facts do not support the state's allegation that this statement by Mr. Robinson was made with an intent to prevent an official proceeding or investigation. Count 6 must be stricken. Count 7 must be stricken because the evidence so they make this argument. Baron Coleman said, you go on to your next strongest arguments. I mean, again, this argument's a whole like page and a half. Their whole argument here, the whole importance of this document is entirely around removing the death penalty, if you haven't noticed. Count 7 must be stricken because the evidence does not establish that Mr. Robinson had knowledge that a child under the age of 14 was present and would see or hear the commission of the charged homicide. Information charges Mr. Robinson in count 7 with substantive offense of knowingly exposing a child under the age of 14 to the charged homicide. I was going to make a joke about that's the one thing that he hasn't knowingly exposed a child under 14 to, but that was too much. That's defamatory to the murderer. In violation of Utah code. This section of Utah law requires that the state prove that a violent offense occurred in the physical presence of a child younger than 14, with the defendant having knowledge that the child is present and may see or hear the commission of a violent criminal offense. So not the thickest charge, although I think it's reasonable to think that he saw children somewhere. But if they don't have evidence for it, I could kind of see it. But I think they're going to have problems, honestly. The state has failed to present sufficient evidence to establish probable cause that Mr. Robinson did in fact have the requisite knowledge. While the state presented a video which shows 2 children, in fact present at the TPUSA rally at UVU on September 10th, the state presented no evidence that the shooter was aware of this child's presence, these children's presence, nor that it says this child's, nor that he was aware of the presence of any other child under the age of 14. Without any evidentiary support, the state invites this court to speculate that Mr. Robinson, from approximately 400 feet away and during a 35 to 44 second period, came to be aware of the presence of children under the age of 14, relying upon Mr. Robinson's alleged walking tour of the campus several hours before the TPUSA rally began. Well, what else are the children under 14 doing at the TPUSA rally? They're not at college, right? So if he saw children beforehand, and I don't know if he did, But if he saw children beforehand, or if they can make the case that it's reasonable that he would have seen the children while walking around, then you've got probable cause. He can dispute seeing the children, but you've got probable cause. If there are children present, he did a walk around. There's no other, like, I don't know. This is a tough one. This is a tough one. But again, if this gets taken off, he still goes to the death penalty. Without any evidentiary support, the state invites this court to speculate that Mr. Robinson, from approximately 400 feet away and I already read this. There was no evidence that Mr. Robinson was anywhere near the crowd that formed prior to the rally, or that he observed children or families with children making their way to the space where the rally occurred. Indeed, the path Mr. Robinson traveled, as visible in the state's exhibits 12.1, 12.4, suggests Mr. Robinson did not even pass anyone that can be identified as under 14 years old. And again, they're going with this speculative, this is speculative on the defense's part, speculative assertion that he didn't see the crowd at all, which is nonsensical. He's looking down at the crowd to take the shot. He likely saw the crowd elsewhere, but he doesn't need to have, because he's looking down at the crowd to take the shot. They're like, nope, he just looked through his scope. Okay. The reasonable inferences might differ if the location of the incident were not a college campus. Why is that? If a defendant were to engage in crimes of violence at an obviously occupied elementary school or daycare facility, well, yeah, it might be reasonable to infer the knowledge required under count 7. Evidence as it is not reasonable inference. This is an event. It's a public event, and he has expressed some knowledge of Charlie Kirk. The fact that there are children there, it being a college doesn't have much to do with it. That's a venue at that point. It's not a college class. It's on a college campus in the public, like in the public square. The violent offense committed in the presence of the child aggravating factor must be stricken for the same reason. There is no evidence that Mr. Robinson had the requisite knowledge. So separate and apart from count 7, the state has alleged the identical aggravating factor in connection with counts 1 and 2. Pursuant to Utah code, the analysis is no different. So these are aggravators for the murder. There is no evidence that Mr. Robinson had the requisite knowledge, and the state improperly invites the court to speculate. An inference is a conclusion reached by considering other facts and deducing a logical consequence from them. Speculation entails the act or practice of theorizing about matters over which there is no certain knowledge at hand. Well, we know there were children there in the crowd. We know that he did observe the crowd at some point, and we know that he had to look towards Charlie Kirk to set up the shot. It's reasonable to infer he had knowledge of the composition of the crowd, which included children. Now, does that pass probable cause? I think probably. I think it probably does. Does it win at trial? I don't know. I think there's more needed, but who knows what else there is. They said the state didn't present the video of him traversing the area, so who knows? The state's backup position that sentencing enhancements are not subject to proof at a preliminary hearing is inconsistent with well-established constitutional law. Now, here's an interesting argument. Lisa Franceschi says, hello, Nick. Hello, Lisa. How are you doing? Nice to see you. Your smiling face. Clippaverse says maybe you did a 360 no scope. Probably. What's up, Clippa? How you doing, man? Okay, the state asserts, we're almost done, guys. There's like a page or two left. We're almost done. I know this has been a long one. That's what she said. And I really appreciate you guys hanging out with me. We'll be done before too long here. The state asserts that the enhancements alleged in the information are not subject to this court's review in a preliminary hearing. That's interesting. The state is incorrect about this important matter and relies on an invalidated distinction between elements and sentencing factors. While the Utah Supreme Court did so hold in cases in the 1970s and 1980s, In the year 2000, the United States Supreme Court squarely held that any fact which increases the potential punishment in a case, other than criminal history facts, are elements of the offense which must be proven to a jury beyond a reasonable doubt. Okay. Apprendi versus New Jersey. All right. In fact, the court wrote, it is unconstitutional for a legislature to remove from the jury the assessment of facts that increase the prescribed range of penalties to which a criminal defendant is exposed. It is equally clear that such facts must be established by proof beyond a reasonable doubt. Okay. Here the state has charged Mr. Robinson in an information subject to a probable cause determination with 2 separate sentencing enhancements, each of which carries the possibility of increasing Mr. Robinson's punishment. All right, but the case said proof beyond a reasonable doubt to a jury. It doesn't say probable cause. So where's your probable cause argument? Utah code requires the sentencing court or the Board of Pardons and Parole to consider whether the knowing presence of a child enhancement has been proven in the course of exercising their authority over sentencing and release decisions. Utah code section 6323.14 is a victim targeting enhancement, which makes one classification higher for the offense for which the defendant was convicted. Therefore, it too is subject to apprendi. Okay. Where the state is elected not to proceed by way of grand jury, but instead elects to present the evidence in support of its information to a magistrate, the defendant's constitutional right not to be tried on any of the charged offenses absent an initial finding of probable cause extends to enhancements that increase the potential punishment. Okay, this sounds great, but notice what's missing. What is supposed to follow a definitive statement of law in a brief? A citation. There's no statute, no rule. In fact, the only thing that they have cited is a case saying it has to go to jury beyond a reasonable doubt. That doesn't mean it's subject to probable cause. In fact, there's a good argument that aggravating factors aren't subject to probable cause. Now, I don't know. You'd think they'd have authority on this, right? You'd think somewhere there'd be a citation that says, oh, no, you gotta do those at probable cause. You can't just bring in a aggravating factor to a sentencing determination at jury trial. It's not like this isn't a post-jury motion for an aggravated sentence. It's not that. Also, Minnesota doesn't follow this in general. So I don't think that that's what it says. This is a logical consequence of Apprendi, which eliminated, with exceptions not applicable here, the distinction between the elements of offense and sentencing factors which increase the maximum punishment. Okay, where is that, though? That's not a citation. The state must prove each of the enhancements to this court, sitting as a magistrate, by probable cause. No citation. You're making things up again, Arnold. Stretching the truth again, and you know it. As to the violent offense committed in the presence of a child, Mr. Robinson has explained above why the state has failed to meet its burden of proof. Mr. Robinson now turns to the second enhancement alleged in this information, the allegation that Mr. Robinson selected Mr. Kirk based upon Mr. Robinson's views and Mr. Kirk's political expression. Okay, so someone asked about political terrorism earlier. So here we're gonna get into that. But they don't have any citation that says that these need to go to probable cause. I think that they don't. I think they don't need to go to probable cause at all. Because if they did, I guarantee you there's a case on point that says they do. I guarantee you. They don't even have authority from another jurisdiction on a federal decision. Apprendi was a federal case. United States Supreme Court, they said, right? In the year 2000, where it clarified all this. So that means that every state would have this question to resolve. All of them. They don't have a single case from any jurisdiction on probable cause being applied to sentencing factors. In Minnesota, sentencing factors are entirely at the judge's discretion. It has to be supported in the record. I don't know that a jury has to rule on the aggravating factors. I'd have to look into it, I suppose. But Minnesota does sentencing different than other places. Sentencing's done by a judge. So here we go. On to this last point they have. The state has failed to produce reliable evidence that the victim targeting enhancement applies here. The victim targeting enhancement set forth in Utah Code is focused on the defendant's perception concerning a personal attribute of the victim. The single personal attribute alleged in the information is Mr. Kirk's political expression, without any further specificity in the charging document. In support of this enhancement, the state proffers two disconnected sets of facts which failed to establish probable cause. And again, I don't know that enhancements are subject to probable cause. I think that puts an undue burden on the state. I think it puts an undue burden on the state to raise all of the potential, they have to raise all of the sentencing factors, the sentencing aggravators at probable cause when evidence may be elicited at trial that would open up a factor, right? Like it's not likely, but let's say someone beats someone to death, right? They beat someone to death. The court determines that they intended to beat that person to death, but there are no pre-trial statements supporting this. And the witness takes the stand because he's awesome. He's a super racist. He says, I picked that N-word out and I beat him to death because I didn't like his skin color. Like, let's say that's elicited at trial. Highly unlikely, but possible. So he makes that statement at trial. You're telling me that they can't use the personal attribute enhancement because they didn't raise it at probable cause because they didn't know ahead of time? I don't think so. Because they can still prove that factor beyond a reasonable doubt. Now, as a personal matter, I know I brought up that example, but I must say something. I believe that hate crimes are unconstitutional. I don't believe that and actually largely I think that this sentencing factor should be unconstitutional as well, because I don't believe that your reason for murdering someone should be indicative of like how okay it is that you murdered them. Like if a guy stole my wallet and I went to his house and shot him in the face, right? I don't think that if I shot him in the face because he's black, that's worse or better. I still took someone's life with no justification. So the question to me should be, did I intend to do it? Like, was it premeditated murder? That's the question. To me, that's all that matters. I don't think assault of someone because they're a minority is a worse assault than assaulting someone because you don't like their hair or because they talked too loud. Assault is assault. The outcome to the victim is the same. The gravity of the assault should be based on the damage that's done, in my opinion. That's me. So I just want to make that personal statement because I gave an example. So one set of the facts, the disconnected facts that they're talking about, is a Rule 1102 witness statement of David Engelhardt. So this is reliable hearsay. A Pastor Engelhardt's statements contain no information concerning Mr. Robinson's state of mind as to Mr. Kirk's political expressions. While it purports to present this court with information as to what Charlie Kirk believed, quote, as all theologically orthodox Christians believe about gender identity and sexuality, it does not identify any specific statements made by Mr. Kirk on these topics prior to September 10th, but he didn't make any after September 10th. It also identifies subject matters that Mr. Kirk would debate and discuss at various events, but it does not identify a specific political expression of Mr. Kirk on such topics, let alone statements of Mr. Kirk that were both known to and motivated Mr. Robinson. Except they have the problem, right? And it's probably going to be addressed in a second. That text message or the Discord message that says that basically Charlie Kirk became too toxic and needed to go, right? Like that message supports the targeting. Therefore, Mr. Englehart's written sermon as to what all theologically orthodox Christians, including Mr. Kirk, believe does not establish that Mr. Robinson intentionally selected the victim of the criminal offense because of the defendant's belief or perception regarding the victim's personal attribute or a personal attribute of another individual or group of individuals with whom the victim has a relationship. The only other fact is Mr. Robinson's statement to Mr. Twiggs. Here we go. I had enough of his hatred. Mr. Robinson does not tell Mr. Twiggs in this text exchange, nor was there, according to Mr. Twiggs, any prior communication between them concerning Mr. Kirk, nor that Mr. Robinson targeted Mr. Kirk because of his religious beliefs or his political beliefs or any other category of beliefs. He refers to hatred and nothing more. Okay, but his hatred is still a personal attribute. Like, what are we talking about here? Ironically, it is the state that argues that because Mr. Robinson and Mr. Twiggs are two men who love each other, and or it speculates because Mr. Twiggs and not Mr. Robinson was at least intermittently identifying as a female to his close friends. It is Mr. Kirk's views on these topics which are the hatred Mr. Robinson was referring to. Well, for probable cause, that's a reasonable inference. These circumstances are not sufficient to establish, even by probable cause, which, if any, political expression of Mr. Kirk motivated Mr. Robinson to select Mr. Kirk for an act of violence. Wait a minute. It doesn't have to be political expression. It just has to be an attribute. The attribute is his hatred. Whatever Tyler Robinson identifies Charlie Kirk's hatred to be, it is Charlie Kirk's hatred that needed to be stopped. It belongs to him. It's a personal attribute. The state is creating an inference, I guess. I think it's a little speculative. I don't think they need to, though. I think the hatred is the characteristic. I'm targeting that guy because he's hateful. Okay, that's enough for me to say that, at least for probable cause purposes, we have targeting of an individual based on their attribute. Okay, so here we go. These circumstances are not sufficient to establish, even by probable cause, which political expression of Mr. Kirk motivated Mr. Robinson to select Mr. Kirk for an act of violence. There is no evidence of specific political expressions of Mr. Kirk, which, if any, Mr. Robinson may have been aware of or focused on. There are no writings attributed to Mr. Robinson on this topic. There are no other statements by Mr. Robinson to third parties which address Mr. Kirk or his political viewpoints in Mr. Robinson's perception of them after searching his residence, his parents' residence, his computers, his telephone, Mr. Twiggs' telephone, and hundreds of law enforcement interviews. There's nothing to base this sentencing enhancement upon other than that single criticism of Mr. Kirk's hatred. Now, there is, although it didn't get introduced at probable cause. Now, so this goes back to the question of, do they have to prove the sentencing enhancement at probable cause? They have to show it there. If they do, they may have missed the bus on this one. But there is an alleged piece of other evidence. The other evidence is simple. Tyler Robinson's family is conservative, particularly his father. According to the mother, Tyler Robinson and Tyler Robinson's father would get into political arguments frequently based on conservative versus less so, probably because he's eating wieners, which I don't know what that has to do with conservatism. In the face of the absence of evidence, the state focuses on Mr. Robinson's sexuality and Mr. Twiggs' gender identity, if only because those are two topics on which Mr. Kirk was, in fact, widely viewed as expressing hatred and intolerance. Why in God's name would you write this sentence if you're trying to say that you couldn't identify the particular political expression? You just did. That is widely known. for having this hateful, intolerant expression. Why would you write this? What a dumb fucking sentence. Absolute madness. Absolute madness that they wrote this. They're just arguing. We don't know what it is. No idea. No idea what he found hateful. The widely viewed hateful one is this. Oh, okay. Thanks, dummies. However, that is not an evidentiary substitute for proof that Mr. Robinson targeted Mr. Kirk because of those expressions. I don't think they have to prove this specific expression at probable cause. Maybe at trial. Maybe at trial. But saying I picked him for his hatred, to me, that satisfies it beyond a reasonable doubt. He says he had too much hatred. He has to go or whatever. They just had it up ahead. Okay, so anyway, it is the state's speculation that he did so. No, it's a reasonable inference. The victim targeting enhancement must be stricken. And again, I am unaware of having to, I didn't consider the question of having to prove probable cause or prove at probable cause the sentencing factors. I didn't consider that question. I'm just going by what the brief said. I will be researching it. I think it's interesting. They have no authority on it, so I'm pretty sure nailed it. No big deal. But that's my thought. Conclusion: in relying largely on hearsay deemed reliable by rule, the state has failed to prove probable cause by reliable evidence that satisfies each element of each of the charged evidence. For this reason alone, this court must decline bindover. So again, this is what Baron Coleman focused on earlier, the roadmap, right? This isn't actually a very good roadmap, but either way, just a throwaway statement that in general, the state failed. No argument on this subject at all. In addition, the state has not provided this court with sufficient evidence as a matter of law to satisfy the sole alleged aggravator in the information. Under controlling constitutional law and Utah Supreme Court interpretation, the court cannot find, based on the state's evidence, that the circumstances presented a great risk of death to another other than Charlie Kirk and himself, and that the shooter knew this high probability of death of another. Finally, the court should decline to bind over on the state's alleged aggravators in counts 6 and 7, where the state requires this court to speculate in the absence of evidence to establish essential elements. There we go. That's it. That's the case, guys. That's the document. The rest is just signature pages and all that stuff. So with that, I'm going to say goodnight because I have to pee really bad, like real bad. And I'm going to go right now. I'll catch you guys later. Thanks for watching. Memberships and super chats and everything. I love you all. Have a good night. Peace.
I am not suicidal. That's what I would like to say. Okay. I am not suicidal. Okay? I am not suicidal. I am innocent, and I am not suicidal. And I am not suicidal. And if anything happens to me when I go in there, I did not do it to myself. And you must all know that. I am not suicidal. Okay.